court accounting class. Are we going to have fun today?
Yes.
Yeah, well, I might as well make it as fun as possible. So my name's Rex Crandell. I'm a CPA attorney in Walnut Creek, and we've been teaching this for the Contra Costa County Court Public Law Library for, I don't know, 5 or 6 years. We have fun doing it. And we also have a YouTube page called Estate Planning California, Rex Crandell, where we put a lot of other videos on different subjects related to estate planning and tax. So welcome you to take a look at that. I'll introduce my assistant, Tamara Brown, here in a moment. This class applies to guardians, conservatorships, probates, and whenever a trust has to do a court accounting. It's required, it's not optional, and it's not like normal accounting for businesses. If you want to do this as a service, there's no license required for bookkeeping. And what you end up doing is at the end of your time that you need to do the accounting, you take your accounting reports plus a petition, ask the judge to approve it. So in terms of trusts, they're the ones that it's optional. And if you're only reporting to beneficiaries, it's not required to use this format, but although we suggest that you do, because it's customary and people expect it. I'm going to come back later and talk to you about a lot of the detailed aspects. But first, I wanted to introduce you to Tamara Brown, my assistant. And she's going to take off. She's a tax preparer, a legal document assistant, all kinds of stuff. Superwoman, mother of four. I mean, she just does it all. And here she is.
Hi, good morning, all.
Good morning.
Good morning. Whew, this is early.
Yes, it is.
See if I can get our brains going this morning, right? Sorry, I'm just setting up the desk a little bit. Oh, maybe not. So how are you all? Good, I hope.
Good.
I wanted to get a little bit about what you're hoping to learn if you're prepare, if you're have a conservatorship, just real quickly, just so I can typically I'll tailor the training a tiny bit based on situations or whomever we have here. I myself have been doing court accounting for many years, and I do have clients that I'm currently doing these accountings for. Typically it's for conservatorships and probate. A lot of times I can do trust administration and other accountings that are needed. Most of mine, unfortunately, are the accountings that go to trial, so they get pretty intense but in nature, but they're somewhat tailored, but pretty much all the same. So I'm gonna go through and first Christine and Steve, tell me a tiny bit just real quickly why you're here, what you're hoping to learn, what type of accounting you're preparing to prepare and what situations you're kind of looking for. Is this your first time attending? Just anything like that.
Hello. I am currently the conservator for my sister Gala Bryan, who's an assisted living facility, and we are preparing. In the past we've used a lawyer agency to prepare documents, except for the very first time we did it ourselves. So we're going back to doing it ourselves again. So we're wanting to learn about filling out the documents, and number one, the accounting, what's required accounting wise.
For the
Great.
fourth accounting.
And so would this be, I'm sorry, your what accounting?
This is the fourth
Fourth.
period accounting.
Okay, great. Awesome. So yours is going to be a tiny bit different than what I explained at the beginning, because I'm going to go through how to start as if this was your first accounting. So the only real difference, you won't be using the inventory and appraisal, which is the first thing I'll go through. You would just actually start the time frame from the last accounting and go forward. So it will be a tiny bit different. So the first maybe hour will not pertain to your specific situation, but it's good to learn and know and see what it took to get you to where you are and your fourth. Okay, Janet, go for you.
Okay,
Good
well, I'm with Christine.
Right on.
So is my sister Susan, who's on here.
Great.
And so Christine said it all very well. That's what we're looking for, is what to do to prepare for fourth accounting.
Great.
We found it takes a village. That's why we're all on here.
Right on. Well, since you guys are all in the same conservatorship and it's going the same way, again, the first part of the workshop is basically how do you start an accounting? What information's needed, what documents you have to pull together and prepare for, and so on and so forth. So what I'll do is, because you guys are the only ones on here so far, I will go ahead and quickly go through the inventory and appraisal. And that's basically how you start, or where do you start when you go through an accounting. But I'll skip pretty quickly past that and show what you guys would do on what you consider the fourth accounting and what type of details and things are needed, because you're not going to need this first hour section. You have already bypassed that part, and this first hour section is if no accountings have ever been prepared and you're starting off. But I do want you guys to realize and learn what it took to get to where you're at right now, and then that will be easier for you to know how you're going to continue on and move forward with your expenses. There are some really important parts which Rex will go through, and that is making sure you have every single bank statement. If the bank does not, if the bank only does online statements, I would request from the bank that they change that and make them paper, because I know even though online is a very nice feature, the court will require original copies of bank statements to be turned in, so that will needed. So what for you guys, the first thing you'll do is gather bank statements and stuff like that, but he'll go through that in his talk. So bear with me while I get through the first part, which is how we started, how we would start an accounting with an inventory and appraisal. I'll quickly go through that, and then we'll go into preparing the accounting, what you need, what you're gonna how you're gonna prepare your schedules and things of that nature. So I'm gonna run the slide. I hope you guys can see this well enough.
Yes.
This is the handbook. We go through, if you wish to download, this is the conservatorship handbook. You can read at any time. I won't go through the handbook or what's there, but all of our teaching material did come out of the handbook. Some of the handbook material is a bit dated and has changed quite a bit, but still it can be used. Okay, I'm gonna zoom out because I think I've got the zoom too high for me. Okay, so how is an accounting started? An accounting is started basically by what we call an inventory and appraisal. Now, when a conservatorship, I'm just going to reference a conservatorship because we're all in conservatorships here. I don't need to go through probate or trust administration, although it's exactly the same. So please don't worry about that part. Let me see. It sounds like I have somebody coming in, and I think we do. Oh, you know what? I have a couple more people, so I'm going to stop and make sure I go through those first. I show Elisa Hunt. Lisa Hunt, you're from another law firm, and you're just going through learning how to do accountings, correct?
Yeah, I don't know if you can hear me. I usually, can you hear me?
I can hear you perfectly well.
Yeah, I work for an attorney in Orange County. We do conservatorships, trust admin, probate, etc. And I've been there 5 years. My issue, I know how to do accountings and INAs and all that, but when you get to uh 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 sorry, I drew a blank. I typed it in. Assets that change value daily, that's where I can't. So I can do simple accountings, and we have an outside person that does when you have investments and all that. And I don't know if you're going to go into that or not, but it's always good to listen in here and pick up on things. I've been here since the beginning. I was just eating my breakfast. So
No worries at all, hun. No, I doubt he gets into the particulars on daily change of value. That's an extremely complicated type of an accounting.
Okay.
I myself do them. I don't like doing them. No, I'm kidding. Because of the complexity of them, this is basically for beginner training.
Okay.
But you may learn quite a bit from it, or there might be little tiny tips or tricks that you learn going through it. But I doubt he gets that. I know he doesn't get that detailed.
Okay. I wish you could just turn in the statements because you're basically repeating what are in them on your schedules. Can't change the law. Okay.
I know
well, thank
it.
you
I know
for doing this, and good luck, everybody. It's tricky. So I'm just going to listen and try to be quiet.
But once you get doing it, or once you get to understand it, it's really not as complicated unless you really do have an interesting estate or an interesting set of assets. Most conservatorships, I can tell you, don't have a bunch of stock trades, don't have a bunch of that detail that can make it confusing and difficult that I've seen. I mean, let's say out of 10, no, let's say out of maybe 20, I get one. So, but I do get it. And that when you have those come into play, it becomes very complicated. But you can listen, you can drop, you can whatever. I hope we give some information that's helpful to you, or you get to learn something. Please understand you can take this class as many times as you want, but most of the time we repeat the information for new people who sign up. So say, for instance, you take the class and you feel I need a little refresher. Absolutely. Sorry. Absolutely can take the class again and start over.
Thank you.
Okay, Shirley, you're last, but not least. Kidding. Honey, tell me a little bit about yours. I think you have your mic muted or.
Okay, sorry.
That's okay.
I'm I'm the conservator of a friend of 40 plus years, and she has no family, and most of her, well, all of her friends have died. So my concern is I've never done this before, and I want to make sure that I get all the accounting that's necessary, and when times they are due.
Okay.
My husband is an accountant, so he's able to help me with some of this. Well,
Yes,
most of it, really.
most of the times I'll tell you CPAs and accountants, this is totally foreign because it does not run anything like tax or anything of that nature. It's just a totally different little ball of wax, but he'll get the concept, so he'll be able to help with that part a whole lot. He'll get to understand you have to balance, understand you have debits and credits, understand those kind of things, but all the rest of the stuff is a little foreign even to most CPAs firms do not even prepare these accountings because they're so different. So I'll bet that's great though, because then I can start from the beginning. So I will tell you, just being new to this, a conservatorship, your accountings are always due. The first one is due 1 year after appointment. That is 1 year after receiving letters, whether it's temporary or whether it is a final. And I say that because some people get temporary letters before they actually get the final letters because of the time frame and the court investigator reports and things like that. So if you received a temporary before you got the permanent, your accounting is still due 1 year from the date of appointment or from the letters. And then after that, it's due every 2 years. So again, first year it's due, and then after that it's due every 2 years. Okay. I'm gonna go ahead.
I had a question. My conservatorship, I had a temporary conservatorship before I got the conservatorship. I think it was in January I got that. April. So is that when the accounting starts, at the temporary one, right?
Yes.
Okay. Thank you.
Okay, so I'm gonna, this is the inventory and appraisal. This is the first form we use to start an accounting. This inventory and appraisal is labeled. I use the codes up in the upper right-hand corner. DE stands for decedent's estate. So it's called the DE 160. A GC 040 is guardianship conservatorship 040. So depending if you have a decedent's estate, we would refer to it as the DE 160. If you are or have a guardianship conservatorship, you would call it GC 040, but it all means the same thing, same form. Typically, these are absolutely blank. I have shown an example here from a law firm as if they were preparing it. So I'm going to go through the beginning stages of it. If you have not done the inventory and appraisal, and we're talking with Shirley, this is where you would start. Although with a conservatorship, typically the court state you have to turn in an inventory and appraisal within 90 days of the date of appointment. That's typically the date of appointment for a permanent. So if you haven't turned in an inventory and appraisal yet, this is where you would start. If you've already turned in one, then you would use it to start preparing the accounting. So again, this is just a sample. Your forms will not come like this. They will be absolutely blank. So I'm gonna go through real quickly what information and where you would put that information. So this top caption right here is basically just the name and address of the law firm attorney. The attorney must put their name and their state bar number. If you are pro per, you would complete this just by putting your name and your address. This would be your telephone number and fax number. If you don't have a fax number, you would leave that blank. It is not necessary or not required. You will see it says it's optional. Your email address. The email address is also optional. Please keep in mind that if the examiners wish to communicate with you, I'd say almost 99% of the time they're sending an email and they're using this email address you indicate. So when completing this, make sure, especially because the information would be confidential, that you're not using somebody else's email address, maybe a friend because you don't have one. If you don't have an email address, please don't use somebody else's, just leave it blank. Here where it says attorney for, that really doesn't necessarily mean anything or mean there needs to be an attorney. You would actually, this is the client for this law firm. You would actually put your name, comma, conservator pro per. And we use pro per to mean you're representing yourself. There is no law firm. Nobody's helping you with this. You would fill in the county of, and typically I ask, but I didn't ask this time. I'm not sure if you all are from, I know, I forgot her name already. Lisa Hunt is from down south. I actually have about 5 law firms where I am a paralegal for law firms down south. So I know the counties and their requirements quite well for down south.
Do you know Christina McGonigal?
I don't, hon.
That's we're in Santa Ana.
Oh, nice. Most
She's
of
well known down there.
Santa Monica, LA on Avenue of the Stars, I have 2. So, and then San Diego,
Mhm.
I have a couple down there. Their courts are so different than up north where I'm at, but
yeah, even LA versus Orange County,
so different.
Different
Even
rules for everything.
And Riverside can even be more complicated.
Different ways to file and yeah.
So in here you would indicate what county your case is being heard or your case is in. So a lot of times it would be Contra Costa, Alameda. In this instance, we're using Orange County. This is the address. This might not still be the address. I don't recognize it, but it might be. And then the city and zip, and then the branch. A lot of times, if I don't know the branch name, I will just put in probate. So down here we have a estate of, it's not necessarily the estate, but it's actually the person. So we're going to use in our sample a Jean Lowry. And you have 3 boxes to mark. Decedent, remember, DE 160 is for the decedent. You have a conservatee, GC 040, or you could have, this could be a minor, a guardianship. And why a minor or a guardianship? A lot of the times, if a minor's parent passes away and they're going to inherit, and there needs to be some matter where a parent must represent, a living parent or grandparent or person will represent the minor, there needs to be a guardianship. And there's several other reasons why a guardianship would be needed. So either a conservatee or a guardianship would use what's called the GCO 40 or reference it. For a decedent, we'd use the DE 160. So moving down the form, this is the inventory and appraisal. You are going to mark either it's a partial, meaning, now let me see when times, okay, so if I have usually it's a probate or a decedent's estate where there's going to be a house sold, and the house is being sold now, but the administrator doesn't have all the assets marshaled yet, or doesn't know what all the assets are. Because I need to verify that my sales price of the home, decedent's home, is within a range, I would do a partial right away for just the house, and wait and do a second partial or final when I have all the other assets. A corrected one would be used if, for instance, and I've seen this often, when an inventory and appraisal is done and it's not done properly, meaning, and I will get through dates and numbers, meaning maybe this number listed as cash assets was a wrong number, was not date of death or date of conservatorship value. It was a different number. If that is the case, you are never going to bounce your accounting, and you will need to file a corrected inventory and appraisal. Most of the time when I'm completing this, I am completing it as if it is a final, meaning I have all my assets here. There isn't going to be any more. This is the whole package, and I don't need any other inventory and appraisal like a partial. If you do a partial, the court is always going to look for a final or a next one, because they know that means you haven't provided them all of the assets yet. Again, a lot of times this could have to do if they're stocks and you're trying to get information from brokers or anything of that nature, or there might be property you don't know about, a life insurance policy you don't know about and you learn later, things of that nature. For a reappraisal for a sale, the reason why we use this one is that if you have, let's use this example, this I'm going to change this from conservatee to decedent. So this is a decedent, and they passed away March 8, 2012. When the probate referee gets this inventory and appraisal, and they're going to value attachment 2, they are going to value that asset as of the date of death. So say the date of death is March 8, 2012. Well, right now we're in 2023, and that value of that property is not going to be the same in 2023 as it is in 2012. And we have a house sale. So the administrator is going to sell the house, get cash, and then distribute it out to beneficiaries. If that is the case, you have to complete a reappraisal for sale, because you have to find out what is the value within a year of it being sold. You need to find out what is the value of the property. So when a probate referee, and we'll get in how you get a probate referee, but when the probate referee receives this and is marked reappraisal for sale, they know that they have to give today's value or market value today, as opposed to using this date that's over here. I don't use supplemental much, but I know it was used. Sometimes a supplemental can be instead of partials. And then you have another one, which I can honestly say I've never used, the property tax certificate. I've never had to use that one. So again, you're marking the box depending upon what exactly you're doing. Now I'm going to switch back and say this is a conservatee. On the right side, you'll put your case number. And in this box, it states what is, remember I used this date of death. So if she was the decedent, this would be her date of death. Now, it says, or appointment of guardian or conservator. That appointment date is, again, if you've done a temporary, it would be the date of the temporary appointment. If you skipped the temporary and went straight to a permanent, then you would use the permanent date. And it is the date the order was signed, not the date you got your letters. So what is the difference between the two? Okay, so you're going to court, you fill out your petition to become a conservator. The hearing is held, and at that hearing, the judge will determine and say, okay, you are qualified based on all your papers and our investigation, you're qualified to be the conservator, and they sign what's called an order. Now, there are times where you will get your letters issued at a different date than your order. Most people, the way it used to work, you would go into court, you would take your order downstairs after the judge signs it, and you would file it with the court. And then at that very moment, you would get a separate document, which you would take, filled out, a separate document called letters, and that is the DE 150. The letters, again, I'm using DE 150 as this number. The letters are what you would use. You typically get one certified, and that's an extra little $40.50. But to be able to change bank accounts, take it to the bank, and change a few things if it is a conservatorship, which, right, the conservatorship account has that person's name, and now you're saying I'm taking over, you would need to show them a certified copy of letters. So this date is not the date you got your letters. And why can they be different? Sometimes an order is given, like I said, you're in court, the judge signs the order, and say he states that there has to be a bond, like you would have to bond. Well, it takes you a couple of days to fill out the bond application, get the bond company to go process that bond for you at the courthouse, and then you go 3 days later and get your letters. Do not use the date of letters in this date box. It's the date the judge signed the order. The order number would be the DE 140, if it's a decedent, if it's a guardianship, it's the GC 140 maybe, or GC 040. It's one of those that would be your order, and that's a date you use here. If you use the wrong date, please understand and realize your counting's not going to balance. Just using the wrong date. Okay, let's move down. Attachment 1. Attachment 1 are cash assets. And again, only cash assets. Difference between cash and non-cash? Cash. Right in your hand, you can see it, or bank, that's cash. Non-cash assets, there we will go through what are non-cash assets. So you will be given the value for attachment 1, which are cash assets. And a probate referee gives value for attachment too. Now, some people ask, how do I know if there is a probate referee? Again, let me refer back to the DE 140, which is the order. The order at the very, very bottom of an order, in the last line before the judge signs it over here, they will put in who the probate referee is. That person is assigned by the court. You must use that person to complete the inventory and appraisal, and that person is going to be paid by you who's asking them to complete. It's not done by you. You can't choose who you want. Now, most of the time on the courts, they'll just stamp a name. Sometimes they'll give you their phone number. Some other times they'll give you their address. So you may have to do a little bit of legwork if they only gave the name to look up, okay, who do I send this, or how do I send it? And you're going to send it via mail, so you need an address. So we're going to go through the attachment ones, and we're going to go there now. So I'm going to change screens. And here's what your attachment one will look like once you've completed it. But when you see it, say you do a search on the internet for the attachment one, it's going to be completely blank. This is just sample of ideas of what you would want on here. So you're going to list the name of the conservatee, the decedent, whoever is on that first page that we had right here. You're just going to repeat their name. Then you're going to repeat the case number. You're going to have to type in attachment one. And you're going to have to say how many pages it is. Typically, it's 1 of 1. Now, here are some samples of what are cash assets. Again, you will not have all of these. You may only have one. There's times that I do these accountings that I don't have any cash whatsoever. Now, if that is the case, I will list item number 1. I will say cash, and I will come over here and say 0. Or I will include in my description right here, 0 cash, no accounts, no bank accounts, nothing. So in this sample, we're going to go through what could be some examples. Again, if you don't have all of it, you are only going to list what you have, not use all of my samples here. So in this case, they say cash found at a residence. I don't like stating that myself. I will say cash found at home, or cash found on conservatee, or something like that. Keep in mind, this is public information. So I try and limit how much information I put out there. I don't like people knowing, especially using the word conservatee, that immediately tells a whole lot of people they're either don't have capacity, they're ill, they're not in full strength, they're older, whatever. I don't like giving that information out, and it just is not necessary. So I myself would just say cash. Now, keep in mind, and I'll say this, and I know us older people, and I'm part of that older people group, but a tiny bit different. A lot of the older people have cash, whereas the younger people never have cash on them. It was such a shift, right? So, and I'm talking this, my father, I use him as a lot of the examples here. My father always had cash, always. And in fact, when my mother passed away, it was, okay, let's go through the house and find how many envelopes of cash we can find. It was almost like an Easter egg hunt, but trying to find cash, and there was envelopes. And my father did the same thing with the younger generation will never have cash, right? Because it's ATM card or apps or something, and just cash isn't the same. No one just has cash anymore. So in your example, you would say you found $250 in cash. Now, most of the time, you're not gonna, let's say, find an exact dollar amount. So say you found $250.50. You need to put the cents in there as well as the dollar amount. Don't just round it up, because the courts, well, they can't verify cash, but the courts go back and check and make sure you haven't done any rounding. So make sure you put the exact dollar amount. Now, balance in the checking account. So I don't put balance, I just say checking account and list the last 4 digits, or you can list 5 digits. Do not ever list the entire account number. Again, public information, anybody can get a copy of this. You don't need, especially for a conservatee, to have their bank account information out there for anybody to see. So I only list the last 4 or 5 digits of the account number. I won't even say balance in, I'll just say checking account and the number. I also do not list what bank it's from. Well, I do. I would put Southern California Savings and Loan checking account. I don't put addresses. But what's really important is this number right here. This number right here must be, and I'm going to slide up again, the balance on that date right there. Now, a lot of times, see how March, let's just use that example, March 8th, middle of the month. Say your bank statements come and they're from the 1st through the 30th, right? And you got a point in on March 8th. You're like, okay, how do I know what the balance was on March 8th? You would need to go ask the bank, or if the bank statement says it, you would use that balance. Do not use the number that's the ending balance on the bank statement, which is a March 30th or a March 31st balance. You will never balance. Okay, again, so you'll indicate that total. And here are some other samples. We have a savings account, the total, CDs, a total, uncashed checks. This is not really used much anymore. Pensions and things of that nature are direct deposited, so I don't find many uncashed checks. But when you become a conservator, your job is to go into the home of the conservatee, go through mail, make sure there are no uncashed checks. If there are, you will indicate it. Now, some people say, well, why wouldn't I just deposit in the bank? Who cares? They're going to see it on a bank statement later. You want to indicate if you found cash at the home. It's part of a beginning balance. Another sample would be an uncashed check from Social Security. Nowadays, Social Security does direct deposits, so you don't see much of that. And then lastly, an uncashed dividend check. For those who may or may not know, if you have a stock portfolio and you reach a certain age, after that certain age, anytime dividends are issued and you have a choice, you can either have the dividends reinvested or you can have those dividends paid out to you in a check each month. So that this is showing an example of a dividend check issued out. So now I've come to my total. 57,844.59. This is date of appointment only, and it is that one day. It means nothing else the next day. It means, has no other purpose except for the exact day of your appointment. It's stopped. It's something in time. And then you'll see as you do an accounting, that's the one that moves forward. So this is the balance you're going to start with. You're going to take this number right here on the bottom, and you are going to put that number right here. Now you've completed attachment 1. You still are responsible for completing attachment 2 for the probate referee. I'm going to slide down and show you attachment 2, very similar to attachment 1, where you indicate the case name, the case number. You're going to call it attachment 2, page 1 of 1, and you're going to list non-cash assets. Here are some examples of some non-cash assets. Not all examples, because there's many, but I'll give you a few more. So in this case, in our sample, we have real property. It's the home address. You list as much details as you can for the probate referee. You may not have all of these details. I do, because I can run copy of deeds, so I can pull this information for the probate referee. But in your case, you would just state real property in the city of Newport Beach. County, you should know the county, state of California. Then I will say commonly known as, and I will list the address, and then I will also give the APN number. You may not have it, but most of the time you can do a search on the internet with the property tax. If you know how to do that, you can get the APN number. If you don't have it, you don't have it. You just give as much information as you can for the probate referee. As you will see, 0 numbers. It's not your job. It's theirs to value the asset. Secondly, in our sample, they have a vacation home. Exact same format as up here. You would list as much information as you can. Household furniture and furnishings, and they're stating where, because you have 2 properties here. This is the home address. Most of the time, household furniture, I myself don't list on the inventory and appraisal. It really has most of the time the value is really nothing, unless you had, let's say, antiques or really valuable things in the house. And if that's the case, I would not lump them under furniture and fixtures. I would specifically list them out separately. So if you have some art pieces, say a piano, anything of that nature that has more value than a sofa you might have bought 10 years ago or whatever, then I would list it and give it to the probate referee to value. In this case, we have shares. Most people ask me, well, how do I know? How do I figure that out? You either have to call the mutual fund company, or you have to get a statement. You have to figure out how many shares this person owned of the stock and list each share separately. So if you have more than 1 share in a specific portfolio, you have to list them separately. Again, you're not giving value, you're just stating what they are. Most of the time nowadays, also when I'm completing this for my probate referee, I will put the abbreviation code of the stock. If you've ever looked at a stock portfolio page, they always will provide abbreviations. So let's say in this case, they were not very descriptive in my sample, but I would state 1425 shares of Apple with Safeguard Investment Mutual Fund code. I don't even know Apple's code, APL, or whatever the code is for that specific stock. And it gives the probate referee a lot more information. And then so he can give value. In this case, this person had 7 US savings bonds. Again, I don't value them, and a diamond wedding ring that's 2 carat. A lot of people have asked me, why is that important? Most of the time, they don't tell me, or in my cases, but to me on a conservatorship, I would think it's very important. The realize that you are the conservator, and most of the time this person has family and beneficiaries, and they might be distant, they might be in another state, they might be whatever it is. Giving them the information about what they have, and I've had cases where I'll use an example. Somebody came in and listed a diamond ring. One of the sisters listed a 2 carat diamond ring as part of her inventory or what she had. The brother comes in and goes, "What are you talking about? I know Dad bought Mom a 5 carat diamond ring. Where is that?" They always want to know these things, right? Where is that? The sister goes, "Oh, I don't know about that. I've only ever seen this 2 carat." Well, here's the problem I would have. One, I can't tell you a difference between a 2 and a 3, 4, or 5. Well, I could imagine the 5's bigger because I just don't know about that, or diamonds were never my thing, right? So I'd have a hard time determining. In fact, I'd probably ask somebody. But most of the time the children know, and if they think you're trying to hide, or another one was with the family I was talking about a second ago. Son, there was a 5 carat and there was a 2. Son was to get the 5 carat to give to his future wife, and somebody else was to get the 2. The sister was trying to give the son the 2, and she keeps the 5 or something. It got very complicated, and it was litigated later. But just write as much information as you have, especially something of value. Make sure you list it on there, and then if they later come back and say, "No, there was more information than that," they had their opportunity. They missed it. You valued what you saw, and that's all you saw. You're not responsible for stuff that you don't find. The other instances that could happen is, say for instance, you really were in the house and you only saw a 2 carat and they know there's a 5. You go back to the house and you look as much as you can, you still can't find it. You're not responsible for stuff you cannot find. And this will go the same way with, we say, even in trust. A trust says you get, or Johnny gets a horse. Well, if that horse isn't alive, or they sold it, or they got rid of it before their death, he can't have the horse. It's no longer there. It's gone. So don't worry, but you're going to, in a conservatorship, if you list stuff on an inventory and appraisal, and then later it comes up missing, or you sell it, or do whatever, you have to report it. But the good thing is you've recorded it here. Now, you will give 0 value. That's not your job. That's a probate referee's job. And it will say total non-cash assets. Probate referee, when they get this, they will put numbers all up here. They will total it at the bottom. Then they are going to come up to this page 2 of the inventory and appraisal. They will fill out what their compensation is, if they had any expenses, and they will give the court and you a total of what they charge for doing that inventory and appraisal. Most of the time, I think it's 1% of all of the assets. They will date it, they will print their name, and they will sign it, and they will return it to you. They will return it to you. It is not their job to file it with the court. It is not their job to do anything except return it to you. Once you get it, you have things you have to do. because you will learn you don't sign or do anything until you've gotten it back from the probate referee. So there are going to be things you need to do. One, this box must be marked all. You can mark these boxes prior to it going to the probate referee. So in here, we've said it's all of the assets. That's why we're asking for a final. If we ask for a partial, you would only mark it's partial or a portion. Number 4, you must mark there's either no probate referee, which means no non-cash assets. They only had cash in a bank account, and you don't need a probate referee because you make the value. Or it's going to be by court order. And that order is, again, the order that you received that has the probate referee's name on it. So again, if you went to court on March 8th and you got an order signed by the judge, it's by order, and you would put the date March 8th, 2012. Property tax certificates. So with a conservatorship, or let's just use a decedent's estate, it is the responsibility of the administrator. Sorry. Of the administrator and the to notify the county, whether it's the assessor, that there is a decedent or a conservatee. I'm almost finished, so it's gonna have to wait a sec.
That's okay.
So the property tax statement, what does that mean? So you actually, as a conservator, will record with the county recorder the conservatorship order. That is your responsibility for any real property owned by the conservatee. So I'm going to use the example. Remember we said, I'm going to slide the screen, sorry. Remember we said this person owns 2 homes, one in Orange County and one in Riverside. You would have to file the order, conservator order in both counties, one in Orange and one in Riverside, because there's 2 properties and they are filed on the properties. You do a blank cover page, you attach a copy of the order of conservatorship. On the cover page, you put the APN number and details of the property and you turn it in. Why? Let me just give you another example or reason why. The reason being is what that tells the county recorder or anybody else is that person is being conserved. What happens a lot with the elder people, unfortunately, is a lot of people want to take advantage of them. Oh, that makes me so very angry and sad and everything else all at the same time. Exactly why I love my profession, and I am advocates for the elderly. I cannot, nothing makes me more angry when somebody takes advantage of them, especially if they don't know or don't understand. And you have a lot of that generation where, say, husband, you know, did most of paying the bills and the work, and mom just took care of the house, so she doesn't understand things. And some people get, and I'm talking friends and family, get the conservative sign over their house or promise them things that they shouldn't be promising them because they don't have capacity to promise. What this will tell the recorder is that the person cannot sign a deed or anything else to give up the house. So that's, it'll ask, so top one is if there is no real property, you only have cash, or the bottom one is if there is real property. Okay, so there's date. You will put your name here, you will sign it. And lastly, the bottom section of the form talks about a bond, which I mentioned earlier. Sometimes a bond will be waived. If it's a probate and the beneficiaries decide to waive the bond at the beginning, the court will give an order of no bond. Otherwise, a lot of times for a conservatorship, there is a bond requirement. Especially if the person had cash, the bond covers the cash value. Other times the court will issue a $20,000 minimum bond. But you will state here, which, and I mean, it's a trick question, so somebody get ready to answer. I would mark bond, or let's say we had a bond. Our bond was $20,000. I'm gonna use the minimum. So I have a bond on file for $20,000, and I need to mark one of these two boxes. Now, my cash is 57, and I have a bond of 20,000. Is my bond sufficient or insufficient? Anybody can answer. I'm sorry?
Insufficient. Insufficient.
Correct. And why?
Because you have to be bonded in the amount, the value of the estate plus the 10% recovery.
Correct. Most of the time, it's just the value of the state, hun. Even in Southern California, the courts, let's say if I state on my application or my conservatorship petition that the conservatee has 500,000 of assets, and I'm just picking a number, the bond will only be for the 500,000. Or sometimes, and that's even if it's for a house, because you can turn a house into cash and things of that nature. But you are correct. Your bond should cover the amount of cash. Now, a lot of times I have completed these and said my bond is insufficient. That doesn't mean the court's going to turn around and say, okay, go get a bigger bond. They may, or they may not. They may say, okay, I think I have enough with the 20,000, but you're just telling it, there's no reason to not say about it. So you would mark insufficient. Now, in other instances, for instance, you have a conservatee and you're going to sell their home, and that's very difficult to do on a conservatorship. So I'm going to say a decedent's instead. So a decedent's estate, and let's say one of 5 kids is the administrator, and the court wants to make sure that the house gets sold and the money doesn't disappear. And I know that seems crazy to most people, but I can tell you almost 98% of the time money disappears. It's quite crazy and interesting. But so what the courts will do in that case is they will force you to put any of the sales received on the house sale or any sale in what's called a blocked account. And that blocked account means that it could never be used unless there's a court order for it. And then you've got to fill out other forms to get money released from a blocked account. There is a fee for every time you ask. And when you do ask, it takes a long time to get it approved. So don't think it's going to be, you file it one day and get it the next day. That's not going to happen. But it just guarantees it doesn't disappear. Okay, then we have date at the bottom. Now, if an attorney would complete this, since you're filling it out pro per, you would just put your name and sign it. And then you would file this with the court. You are going to file page 1, page 2, page 3, and page 4 all together. Are there any questions oh geez, I went too far, I'm so sorry. Are there any questions on completing the inventory and appraisal? None? Y'all are good. Okay, so now what's going to happen is Rex will come in and start the accounting portion of the class, and then I will.
I had one question. I'm sorry.
Yes, no, go ahead,
I
hon.
didn't know I was on mute. So just for clarification, those of us who are here for fourth accounting, we are not gonna have to do that part again.
You already did an inventory and
Yeah.
appraisal.
So we're done with that. Okay, thank you.
Yes, so you guys, what will be different for you guys, I'm gonna slide down, and please ignore, I'm probably making you all dizzy by doing this. What you guys is, you've already had a 1, 2, 3. Instead of naming this first, you would name it your fourth or fifth.
Uh-huh.
And then you're gonna pick up from the exact one day after your last one was done. You're gonna pick up that date and put that as your start date. So see how I have March 7,
Right.
2013? You would put March 8th, 2013, and you're gonna go for 2 years.
Yeah. And what
Right.
page is this form that you're on
This
right?
is the GC 400 sum, which Rex will go through, hon.
Oh, okay.
But this is what was turned in your prior 3 accountings.
Okay. Okay.
And then the only other thing for you is typically your starting assets, which is the number here, remember came from the inventory and appraisal. I'm skipping. He'll go back through this in much more details. But instead for you guys, your number of cash assets, you'll pick up from your prior third accounting, you'll pick up this number that's at the bottom, and you will put that as your starting cash
Okay.
asset. Same thing for the non-cash. So yours is going to start a little different for the fourth one, hon.
Okay. Thank
Does
you.
that make sense?
Yes.
Okay, so remember, you're gonna go back to one that's already been done and filed and, you know, completed and agreed and accepted, and you're going to pick up right from there.
These numbers will become our beginning numbers up there.
Right, so these
Yeah.
numbers that ended on your third will become your beginning ones on your fourth,
Gotcha.
okay?
Yep. Thank you.
You're welcome. Is that the only question?
That's the only one I have right now.
Perfect. Okay, so I'm gonna give this over to Rex. Again, I will come back at the end because he's gonna go through the accounting, and then I'm gonna pick up once you have the accounting. What do you do? What do you provide the court, and how do you get it approved?
Okay.
Okay, so I'll see you all soon.
Thank you, Tamara. Okay, so we'll go for another 30 minutes and then we'll take a 10-minute break.
If you take a break, we're not gonna end on time.
Well, we'll have to move it along because we're going to. Okay. Now, I'll get you situated in a second when I find out where I'm at. Okay, so let me move this. Hold on, I'll be with you in a second here. Done. Okay, so I don't know if Tamara went over the page formatting for our handouts. Hopefully you pulled them all down from your computer because we have 4 of them, and I will explain what we have here so that you know, and I'll come back to one of them. There's one of the handouts is called handout non-follow along. And this one is additional helpful information that we've pulled from the court to help you with understanding what's needed for the court accounting. And it's fairly short and simple. And then we have some sample pleading paper if you want it. And I pulled some useful items. This one is a sheet that has probate code sections that you can look up something if you have an unusual transaction and you want to know what's this all about. So it's quite helpful in specific situations. Then just let you know, we have a spreadsheet program that we make available for $50. It's court accounting, just a model. It's not the most sophisticated in the world, but it does work on Excel for those people who like Excel. This is an order form. And then I have gone to the probate examiners and gotten their sheets with permission on how they evaluate accounting when it comes in. So this is kind of what you're going to be up against in looking at your documents. Have you done that? So one for a, is there a statement about a bond? Has the petition been verified, signed under penalty of perjury? So those of you who like, and the CRC is California Rules of Court, and if it doesn't say what the statute is, that's the probate code. So these are helpful for the more sophisticated people doing the accounting. And last one's trust. This one's for estate administration. That's just a little stuff. I think that's all the good stuff left. So that's our number 3 non-follow along handout. Then the number 4 handout is if you would be so kind at the end to give us an evaluation and send it to Carrie Rowan at the law library and a copy to us. Any improvements, anything you think we should have added. And I have another handout I'm going to discuss later, which is another example of a complete accounting, but all on computer, not using government forms. So right now, we're going to go into the nitty-gritty of doing the accounting. And this will be done at the end of the first year after your appointment, and then every other year thereafter for guardians conservatorships. And so you're doing your first accounting at the end of 1 year. So it's years 1, 3, 5, 7, 9, are the 2-year intervals that you'll have to go back into court and get your accounting approved. This particular form is a GC 400. And so it says GC 400 sum, which means summary. Most all of these forms that we're going to be looking at today are also called GC 400, but they have another letter attached to them to make a distinction. So, but this particular form is paramount for you to understand and use. It's kind of like the spokes of a bicycle wheel. It's the center hub. Everything has to come back through this form. And even if you do your accounting 100% on computer, you must use this form as your top sheet that summarizes everything. So you notice down here in the lower left, it says adopted for mandatory use. Not maybe, not if you want to, you're going to. So it's for probate, guardianships, conservatorships, and any trust that reports to the court. So we're going to be moving through a lot of pages, and so I don't lose anyone, I want to point out the numbering system. So I have added numbers to every page, and they're in the lower left, and I couldn't get the zeros to go away. So this one we're on right now is page 21. And we're going to be looking at a lot of other pages, but continually coming back to this one. So if you printed it out, you might put a little yellow sticky note because we'll be going back and forth to this particular page. I'll give you some other information about the forms, and on the lower right of every form, it says here, this is probate code section 1060 to 1064. Well, if you have a question, you can go to the probate code, it's all free online, and read that. And here's the other one, California Rules of Court. So those code numbers change depending on the form, and I'm not saying you need it, you don't have to look at it, but if you want to, that's where you aim right into the code. So, summary of account, affectionately known as GC 400 sum. If you're a guardianship or conservator, they have a parallel name for it, GC 405. You start out putting the name of the conservator or guardian, and if it's a trust, you would write the trust, case number, and whether this is the first or second accounting, fourth accounting, whatever you're doing. And we're assuming it's your first, so that would be after 1 year from your appointment when you got your letters. So the time period is from date of your letters, March 8th, through the next year, March 7th. And then you will also include bank statements with that, and we will cover that aspect of it. If you're doing a probate, it's going to be from the date of death as the opening account date. We're going to be doing standard accounts, and I'll cover the simplified in a bit. I'm not going to cover it too much. So Tamara had explained everything you need to know about the inventory and appraisal. And those numbers go here in the beginning, just the totals off of your inventory and appraisal form. Beginning cash, beginning non-cash, total amount at the beginning of the period. Then this form is divided in two parts. The upper half is what you got, what you have, and what you did get during that accounting period. And the bottom half, credits, are where did everything go and what's left. So these are all, you don't use minuses and pluses, but these are all money coming in, recaps, gains on sales, received, property, and then these are all going out, disbursements, credits, distributions to the conservatee. And then we do another equivalent to an inventory and appraisal without getting any new actual appraisal forms. And this is what you have at the end. So another way to look at this charge, this is your responsibility. You're charged with the responsibility to tell the court everything about where that money went. And if it doesn't add up, you're personally liable. It's not even maybe. And it's also, we have this thing called carry value. So that's used quite a bit for non-cash assets. And someone had asked about securities and change fluctuation of values. No, you have carry value. Let's say we're doing a probate as of the date of death. It does not change. I don't care what the stock market does. That group of securities or that Merrill Lynch account has a carry value at the beginning that does not change. And same thing with houses. You get an appraisal in the beginning. Yeah, the real market's going to change, But you have to realize the court is just looking backwards to verify that you, the fiduciary's done what you're supposed to do. And that way they can track the funds for the benefit of the ward, conservatee or guardian. Okay, so when you're entering your data and you've got summaries and you have nothing on that line, put a 0, because you're making an assertion. Not that I forgot that line, or I'm not telling you. 0 is an assertion that they want a 0 on every empty line. Some of these forms have schedule letters. And then you will be adding additional schedules from time to time based on the transactions and asset mix for your estate that you're reporting on. And so what I suggest here is when you add schedules, don't continue using alphanumeric or alpha letters. Switch to numeric. So you got schedule 1, schedule 2, you're adding. And the reason why I'm saying that is when I first started this, I looked at these numbers, letters, and said the next one I'm going to use is E. Well, E's way down here. So if you switch to having schedule 1 and schedule 2, whatever numbers you want, but it doesn't conflict with what is already here in the beginning. Another way to remember the carry value is 2 things. One is burden. I mean, it's like you're carrying these bricks, gold bricks on your back. And so you have responsibility, but it's also a burden that you're responsible for. So what we're going to be doing here, if this was a website and these were all links, you would, like this Schedule A, you would click here and then it would bring you back to all of those schedules. Well, this is done manually, so you don't have a computer to bring you there. You will go in order of the forms. Now, don't confuse, if you happen to know accounting, credits with debits and credits. The court couldn't do that. It would be too simple for everyone. So it means nothing like debits and credits. These are really like disbursements, which normal accounting would be debits. So forget debits and credits. They don't teach any of this in accounting school. I'm a CPA and a lawyer, and they didn't even mention this in CPA school or on the CPA exam. This is a function and a derivative of California state law, and each state has a little bit of a variation. So basic format, yes, in other states, but not exactly. And if you have assets in another state that are part of the state you're working with, you do not list them on the accounting. You have a rental property in Idaho. Well, it doesn't even show here. It's like, okay, so what? It's because California court has no jurisdiction over it. It's not that it doesn't get disclosed, but it's not part of your accounting. So first of all, who are the probate examiners? So the judges have a group of helpers, assistants, whatever you call them, and they're known normally as probate examiners, and they look at your work when you turn it in before the judge looks at it. And they will go through it and find things that they agree with or don't agree with And when they don't agree with it, what they do is they prepare what's called a tentative ruling or examiner notes. And at least in our court, in the San Francisco Bay Area here, those examiner notes are available to you generally 10 days before the hearing. And it's like turning your paper in and being graded by your high school teacher. Hey, bud, you didn't quite do this right. No. You didn't follow the instructions, and they kick it out. And so what your role is as someone submitting these is you need to first look through your court website, find out where your particular judge has their details, examiner notes, and keep looking at it until your hearing date comes up. And then you scroll down, like say, if you're item number 10 on the docket for today, then you look and see what it says about what you did. And what you do after learning what it says is you get on it right away to fix whatever it says, however you need to fix it, and get it into the court immediately. Because if you blow it off, or a lot of people don't know about it, when you get to court, the judge is not going to spend much time with you at all. They're going to take the examiner notes and say, that's my ruling. You left out X, Y, and Z. Tough luck. Come back in 4 months. Have fun. So you need to do that. You need to look at the examiner notes.
Rex,
Is there a
I'm
question?
sorry. Yes, just for clarification. And where do we go to look for those examiner notes? On the county
Okay,
webpage?
so each of our 58 counties in California have a superior court,
Mm-hmm,
and your superior court will have a website for
mm-hmm,
all the activity related to that court. And
correct.
you will do a search on that section to find the examiner notes or tentative rulings for civil cases. And when you find where that place is for your particular judge, you'll drop it down and it'll show hearing dates. And if your hearing date's November 15th, you monitor that date for your helpful suggestions about what you might want to do. And I would also put it into a bookmark on your browser so you can go back to it really easy the next time because for most of the time after you file, there's nothing there. And then hopefully 10 or more days before your hearing, then you get informed as to what you should take care of on your accounting or petition. Another thing that you can do in our local court here, I've gotten permission from the court, is the probate examiners in the probate department generally have public availability hours where you can just walk in and talk to the probate examiners. Sometimes they're rather busy, but the purpose is you bring your accounting in before you file it, and you ask them, could they look at your accounting for format, and tell them that you're not asking them to look at it for content, because they will tell you they don't want to approve anything until they really approve it. So, in our court, we'd go in and say, I did this accounting, I've never done it before. I want to have you look at it to see if my format is correct. Ignore the numbers, the content, just tell me if my format is what the court would normally expect. And they've agreed to do that. So it's not only will you get examiner notes, but that's a way to talk to the teacher before class, essentially.
Okay. Thank you.
And you might also look at the sheets that I gave you on handout number 3, because at near the end of that, I gave you the checklist that was used at the time they gave them to me. And it says you should have done this based on this code section. You can check your own work a little bit. Okay. So what we're going to do now is go through the detail of how do you get here? How do you make this summary sheet? And we're marking page 21 because we're going to be coming back to it. I'm trying to find something. I'm not finding it too well. Okay, so this is the next page 22. I take that back. 21-1A. So what this form is, this is the start of your accounting, and this is basically your beginning inventory and appraisal. It's just a copy job when you're first accounting. And then in subsequent accountings, the end of your prior accounting will be the beginning of the current accounting. And the courts are very particular to monitor what was the ending on the prior balance report and what's the beginning here. Because if there's any difference, something fell through the cracks. So all you're doing here is bank account, maybe the last 4 digits of the account number, and what was the balance on that date. And the date we're talking about right now is March 7th. So simple deal. Bank account, last 4 digits, and what was the balance. Now, non-cash, this is the same thing. You have assets on your beginning inventory and appraisal. And you just, this is a copy job again. You put the carry value all the way down, matches what you already had. But after your beginning in inventory and appraisal, there's a column that says estimated market value. Now, that's just a guesstimate. You don't have to get an appraisal. If it's a house, look at Zillow and just approximate. You're not bound to it, but they do want to know, and you just list what the market value was on that date and indicate it on the form. So that's pretty straightforward. And you don't have to use this market value on your first account, because guess what? You did that whole inventory and appraisal so you could come up with carry value, and that's the same date you're talking about. So nothing's changed. That is the market value. Another comment that probate examiners, a technique or procedure, is that when you give assets numbers on your asset list, like asset number 1's a house, asset number 2's a rental, asset number 3's a Merrill Lynch account, never change those numbers in the future, no matter what happens. If you close the Merrill Lynch account and you no longer have asset number 3, leave that 3 blank and then continue on, because it makes it really difficult for the court to track what you did from one year to the next, or one report to the next, if you've changed the asset numbers. Okay, so let's go on to page 22, which is an optional form. It says don't file it with the accounting. And what this is a summary sheet. So this is like an interim step. I happen to like the form. So you might have 4 pages of dividends. You might have 3 pages of rents. And in order to determine how your numbers are flowing together, this could be a summary before you go back to the GC 400 sum. But it is optional. I happen to like it, but I'm a nerd, so whatever. Now, we're getting into the receipts section. And you list every transaction. So the broker statement, you have to list every dividend. There's no question about it. You cannot group them. So, and when you do that, you'll find if you have a dividend reinvestment program that it'll drive you crazy, because you have a dividend you got to report here, and then you reinvest it. Guess what? Now you have a purchase. You got to report the purchase somewhere else, and it doubles up your work. Don't let the broker reinvest the dividends. Say, no, put it in cash, and every time it gets above 15,000, I'll do something with it. But that'll cut a lot of work for you out. By getting the dividend reinvestment program removed. We abbreviate that DRIP, dividend reinvestment program. Overall, in this court accounting, the Judicial Council has come up with 48 different forms for different kind of transactions. And don't think you're going to use them all, but I'm just telling you that we're only going to use the most common in our descriptions. So,
Rex?
yeah,
Sorry. You're talking about like Edward Jones, Charles Schwab type stuff here?
yes. Because dividends indicate that you have stock ownership or mutual fund ownership.
Okay. And any dividends that they earn on these, you're saying have it put into a cash and then invest it at a later point, like when there's 10,000 or something?
I am saying that.
Okay.
What most people do is they say, oh, hell, just reinvest it. I don't need the money. Well, that's okay if it's your personal account. But when you're doing accounting for every penny and you reinvest, that's a purchase.
Okay.
Now you got to track a 34-cent part of a stock security that you bought, and that becomes a new item that you have to track all the way until it's sold. So, I mean, major nuisance.
Okay. Thank you.
Sure. Okay. So next we have interest. And on interest, for each bank account, you write the bank account, maybe last 4 digits of the account, and every interest payment in the statements are going to show here for each of the accounts.
So if the interest is only like 12 cents or something, we have to list that?
Yes, ma'am.
Okay,
With IRS and income tax, because I do a lot of income tax, IRS says, hell with the pennies. No, they say you can round off with the pennies to the nearest dollar. So on income tax, there are no pennies ever.
right.
But for the courts, they're more anal about it, and they just say, well, pennies, yeah, we want to know every penny. I mean, 3 cents. It's ridiculous, but that's what the rules say. There's no exception for under 50 cents or anything like that. So okay, we've been going for an hour and a half, and we're going to go for another hour and a half. And I'm going to stop the program for 10 minutes to give everybody a stand up and stretch break. And so if you'll come back in 10 minutes, we'll continue on. Okay, we can get started again now that you're refreshed and had another cup of coffee, whatever. We'll move right along. Okay, the next section, we're on page 25. Has to do with pensions. And the form here shows that you list any pensions, but for some reason, Social Security and veterans benefits go somewhere else, and list each individual pension payment. And the next schedule on page 26 is rents. So unlike a tax return, like a Schedule 1040, Schedule E, where you have income and expenses by categories, it's not that way in this accounting. You just peel off the income and it goes to the income, and then wait till later, and then we'll deal with the expenses.
Rex, I have a question.
Go ahead.
So what we have been doing, we're on fourth accounting for us. Instead of itemizing each standard account like rent and prescriptions or whatever, we have done it by month. So can we submit that instead of itemizing on different pages? You know, like we have to go back and pull out all the rent and itemize it on this form, or can we?
I'm trying to understand what you're saying, but I'm not quite getting it. But here, each rent is showing by month.
Right, but we have a spreadsheet, Excel spreadsheet. So for the month of June, we would have the rent in there, we would have pension in there, the date it was filed, the category, we would have Kaiser payments, we would have.
Now I understand. So you're doing a separate accounting for each month.
Correct.
That's hard to follow. I would not do it that way.
Okay.
I would take your whole year and put everything and skip the monthly totals. Because like in this example, rental income each month, and it shows, they go, okay, well, I see there's no vacancy this year. On yours, you'd never be able to see that.
Okay. Okay. So we'll have to separate that out. Okay. Thank you.
You're welcome. I would also describe what you're renting, if it's a 4-plex or 8-plex or something like that.
Yes.
And down on the bottom right here on page 26, we have the income item Schedule A with different sub categories. We're on 4 of 6. So we keep going in the A series. And then these totals on the bottom are subtotals. They're not accumulated.
Well, you're talking about income. She's talking about expenses.
Well, it's the same comment and same opinion, no matter if it's income or expense.
Okay.
Okay.
Yeah, it's just one way on income, you'll be on A. If you're on expenses, you're going to be on Schedule C.
Okay. Thank you.
Now, where was I? Should have got the page.
We're on
Yeah,
27.
this one. This is the one on page 27. So we had all the probate examiners in our local court are required to take our class. We had a probate examiner in class, and she looked at this form and she said right off the bat, you can't do that. You can't take 3 months and group it. You have to show every Social Security check. So that's what they're looking for.
Okay, so do not group.
No, don't group months.
Yeah.
Each,
Mine-
a nickel comes in, a nickel shows. A nickel goes out, a nickel shows.
Got it.
Now, in Social Security, as you know, there's the total amount of Social Security. And then there's what they pay out in cash is less. It's not cash, it goes directly into your bank account. But the question comes up, how much do I report? The total or what came into the bank? Well, you're only responsible for money that you can control. You can't tell Social Security, don't withhold Medicare. They just laugh, you know. And what you got in was the net amount. That's what you report. Cash in, cash out. Now, just to give you another example of when netting is not appropriate, let's say you had rental income of $2,000 a month and the porch needed work and the tenant says, well, I'll replace or repair the porch for $500. Well, you cannot net two different directions of transactions. You would have to show the rent of $2,000 and then show the barter expense that caused the income to go down as an expense for repairing the porch. Okay, other receipts. If you haven't found a category so far, this would be a good place for it. Listing state tax refund, insurance reimbursements, things of that nature. So we're leaving that. Now we have page A6 of 6, and our next form is Schedule B. So when you're leaving that section, we're on page 28 at the moment. When you get to the last set of forms, you go to your GC 400 sum and bring in, enter all the receipts for all the different forms that you've done in that Schedule A series. Just bring in your total. And if you're like me, I will, where's my favorite form? Where'd it go? Here. I bring them in by categories. You don't have to. So now we're going to switch. We're out of the A series. We're going to go to the B series of income. If I can find my place again. Yeah, right here. Now, Schedule B, GC 400 B, and we start out page 1 of 1, and this happens to be gain on the sale of assets. Okay, so we had the house appraised at $230,000 in the beginning. That's our carry value. And we sold it for $250,000. That's the contract price, ignoring all sales expenses. The sales expenses we'll get to later. And so it says that we had a gain of $19,000. And that's what they want to see, that gain of $19,000 compared to your carry value. But in reality, you really didn't make that because you probably had $30,000 of closing costs, which I'll show you later. But this also works and is required for stocks because your beginning value is your carry value. And then when you sell it, whatever the market is, and then the asset number, this residence, let's say it was asset number 4, is now gone. And you won't use that number 4 asset again. Now we'll go to another. So let me stop here a second. We're done with the Schedule B. one of one. And so you'll bring that back to your summary sheet right now, 19,000 of income. And we're going to switch out of the Schedule B forms, and now we're going to go to another type of Schedule C forms. Disbursements. Now we're going the other way. The money's flowing out. And in this case, person has professional nursing care facilities, and each month you're showing the amount. We had one client, he had 150,000 of living costs for 1 year, quite high. And then we're on page C, and we're on 1 of 8. We continue on with the subject matter on page 31. Now disbursements, general and administrative, for managing the ward's activities. So we have attorney fee or conservator reimbursements, court filing fees, probate referee fee, and insurance bond payment. As the attorney and the conservator cannot get paid until they get a court order allowing payment. Getting reimbursed is a little bit different because you're turning in a receipt, and you loaned the ward the money, and that's why you get reimbursed. So we're on page 2 of 8. We'll continue. Now, living expenses, just list, we have cable, hospital bills, different kind of expenses, what the person needs or wants for their living costs. We'll show here is money flowing out. If these show check numbers, and the assumption was that they're all check, but they can also be credit card or debit card. Now we'll go to page 33. Now, medical expenses, you just list them, and the amount that you would pay if the insurance company was paying some of the medical, you would only list the copay. What insurance paid doesn't matter. So medical is pretty straightforward. Then we have disbursements. Now, this is the other half of that house sale. Disbursements, property sales expense. So we have escrow, termite, broker commission, payoff of the mortgage. It's funny, on your dealing on a closing statement for a house sale in court accounting, there's one number on an escrow statement that you never use. And it's ironic, but it's the net cash coming in. It doesn't have any place to be posted. You posted all the gross numbers, all the sale price, all the expenses going the other way. The net amount of the accounting will have that cash amount, but you don't see it anywhere here. Okay, so disbursements, again, we're on page 6 of 8, disbursements in Schedule C. We have, in this case, we sold some beach furniture, whatever, and this was a commission, a consignment fee. And we show the asset going away on a different schedule. Now, disbursements for the rental property. I would list each property in a separate group. But in this case, it's just chronological, and we only have one rental anyway. And it seems kind of unusual, you know, you're mixing insurance with loan payments, and this loan payment is principal and interest. You're not breaking it out between principal and interest like you would on an income tax return. Okay, now the Schedule Cs. Miscellaneous, you got tax prep, IRS, tax balance due. And now we're on Schedule C 8 of 8. So when we have the last one in the C section, I don't think that's the right word, page C 8 of 8, then you know that the next step is that we're going to the summary to list the total of all the Schedule C disbursements on our GC 400 sum on page 21. So we're moving through, and you'll notice that we've gone through the income items, so we can do a total on beginning plus the income and get a total for line 7 now. And we're working our way through the expenses. And now we have another asset sale on Schedule D. And we have the carry value, what you sold it for, and gain or loss. So, and you'll notice this little notation. So you're telling the reader, the judge or the probate examiner, inventory and appraisal attachment number 2, item number 7. So they can hone right into it. So, and we're on Schedule D, it's 1 of 1. We don't have any more D. So guess what? We go back to the GC 400 and bring that loss on that sale forward. Now we've gone through the income items and the expense items, and in our progress report, we are here. So we went through the income, we went through the expense, and now there's no more expense. What we're going to have to do is, what do we have on the end of the account? So we need to indicate that. Where's not too far? Losses. Yeah. So it's just like our beginning inventory and appraisal. That's not what this is called, but gee, it looks just like it. GC 400E is the cash at the end of the accounting period, reconciled to the statements to March 7th for each of the bank accounts, just what the dollar amount is. Now, the non-cash assets, what we're really being graded on or being tracked are on the carry value. So you just list them again by asset number. You know, we have these bonds left over. We have the residence at the end of the time and a wedding ring. I would be careful about identifying things. Like I couldn't tell a diamond ring from a cubic zirconium. So I would just call it a ring. Because I don't know, and no way I can know. So when you get done with the cash and the non-cash, we're going back to the GC 400 and adding the cash, the non-cash, and then it needs to balance at this point. So what came in, what went out, what you had in the beginning, what's left, and that's just the first thing that the probate examiners look at. Does line 7 equal line 14? If not, you're not done, and you might as well not even turn it in.
I have a question, please.
Go ahead, ask.
I've always gotten a little bit confused. Your carry value is your inventory every accounting period versus your market value. You're estimating what the value is, but you're not using that in your GC 400. Does my question?
Correct. No, I understand
Okay.
the question and you
Okay.
are correct. So what this carry value does, so they can track you from your beginning inventory carry, that's your burden during the entire accounting. And the market value doesn't amount to anything. What the market value is good for is protecting a fiduciary. Say they've got a really lousy investment ability, and they wanted to make a small fortune, so they started with 100 million, and now after 2 years they only have 50 million. Guess what? That tells the beneficiary something's wrong here. Plus, it discloses it so the fiduciary, the beneficiaries don't object that, well, you knew about it, why didn't you object?
Okay, so
So-
your market value is going to be, say, these safeguard shares. You're taking that from the actual brokerage statements, but you're using the carry on your summary sheet.
Yeah, yeah. If
Okay.
you're not accounted, or you're not, you don't have to reconcile, justify anything on the market value. Like if I take Zillow at the end of each accounting and just throw a number in, well, how'd you get it? Zillow.
Okay, gotcha.
But your carry value never changes until the asset's gone or until the fiduciary is no longer representing the estate.
Gotcha. Okay. Thank you.
Sure, sure. All right. Now, we've gone through all the disbursements, and this is your plan. You should, really understand how that works. There's another form that I wanted to tell you about that's important and frequently omitted. It's Schedule F. I don't have it in the material, but it says change in form of assets. Change in form of assets. What the heck could be on there? Well, if you have a Chase savings account and you close it, and the funds go over to Wells Fargo, well, that would show up here. The form has changed. We have a different vendor. Okay. And if you had like securities at the beginning of the account and they've all been sold, those now we have them in cash. What was an example of probate examiner gave me was like, say you have stocks, you have Apple stock and it splits 2 for 1. Oh, well, that's a change in form. How'd you get those extra shares? Schedule F will show it.
So Rex,
Yes.
so if we used to have the money in Charles Schwab, and then we closed that and we moved it to Edward Jones because we wanted a different vendor, whatever you call it, we would use this form.
You would use this form to show the change in form. However, depending on how you transferred the securities, you may have another reportable transaction. And so first off, if you went from Charles Schwab and sold everything, now it has got to show up on sales too.
We did not do that. We just changed to Edward Jones. Is that
Okay,
right?
Let me clarify your statement. When you take stocks from one stockbroker and move those stocks to another stockbroker in estate and trust talk, that's called an in-kind, IN-KIND, transaction. And that would be a change in form, and there is no sale reported, only the change in form. And I do that all the time. When I'm distributing an estate, I ask the beneficiary, do you want to sell everything or do you just want to keep the securities and avoid the brokerage statement? And frequently they want a distribution in kind.
So we would use this form to report that.
Correct, Schedule F.
Okay. Thank you.
And then you have a new item, a new number on your asset list, inventory and appraisal. From that point onward, now you have an Edward Jones account. And it would show up on your ending inventory and appraisal. So I want to cover some problems that come up, common problems. One is the GC 400 doesn't balance. Another is the expenses are unclear as to how they benefited the ward. You have expenses, let's say for a hot tub, and why does the ward need that? I mean, is that really the conservator wants a place to hang out? So you should show, oh, it was medically required because of a back injury. So you explain the content, or correction, the context or facts and circumstances on why that expense should have been paid and why was it reasonable. Other problems in accounting is showing assets that bear no responsibility of the fiduciary, confusing responsibility and confusing market values, confusing fiduciary accounting with other types of accounting. And that could be a real problem for a fiduciary. Say you hire a CPA firm and they say, we know everything about court accounting, and they don't. And you pay them a fee, and it's in such a weird format. It's in California or business format. And now you've got an expense and you've got to hire somebody else to fix it. The fiduciary may have to pay that out of their own pocket. And we've had situations where bookkeepers will say, well, I know everything about fiduciary accounting, and they do absolutely nothing. So missing data, other problems writing checks to the fiduciary before court order, or fiduciaries paying themselves before the beneficiaries. When you're doing your petition for approval of your accounting, in the text that Tamara's going to teach you, you don't need to put in there that there's no California state tax. Probate examiners say you haven't had state inheritance tax since 2005. Other filing requirements, when you turn in your court, your bank statements, you have to turn in original bank statements. Our court says no colored paper to separate the bank statements. And our court does not want you to staple the bank statements because they're scanning everything in. And if you go to the court and talk to the probate examiners, they don't want you to argue the case before them. Save that for the hearing. Another helpful suggestion is a reference book. An attorney over in our county, Margaret Hand, has written a book on fiduciary accounting, and it's available from CEB, Continuing Education of the Bar, and it is called Fiduciary Accounting Handbook. And I can't get it, they're kind of focused on it. It's quite expensive. You know, it might be $250, and but it's huge. Don't think you're going to learn court accounting with this book. You won't. It's a reference book. You're trying to figure out something. How should I present something? And you're looking at a specific topic, and you'll probably find 2 or 3 references of it in the index. The other thing is when you complete this class, if you want to impress your friends, and you want to have a certificate, send us an email that says, wow, I suffered through that court accounting class and I'm the better for it. Whatever, if you want one, there's no MCLE, but it will impress your friends, I doubt. But
So
now,
Rick,
go ahead.
I have a question before you leave, so I don't know if you're getting ready to get off the screen or not, but do you want me to ask my question?
Oh, please do.
Well,
Like questions.
you had mentioned that we could pay $50 and get some kind of accounting thing. So I
Right.
see your form here, but I
Yeah.
can't remember what we would be paying for.
Okay. Are you familiar with the program Excel?
Yes,
Do you have it?
yes.
Okay. It's an Excel template that has been set up that models what we were talking about here. And this is like an example on the screen at the moment, how it might look in Excel. You can't use this first page. You notice this looks like our favorite GC 400 sum.
Right.
Not by accident. And then all the other schedules, we have set up tabs for different schedules. So what it is just it's not super sophisticated, but you have tabs for rental income, tabs for
Uh,
living expenses, tabs for, and you can use those because the GC 400 is required. All of the other forms are approved for optional use.
Optional. So,
See, look at the bottom of this form. It says approved, this one, receipts. Approved
optional.
for optional use. Use it if you want. The county court at Riverside has fillable PDFs of all these forms all in one file. So that's kind of nice if you decide that you're going to use these judicial council forms.
Otherwise, we could pay the $50 and use a form that you have produced like that because it's optional and use your form.
Yeah, we call it a template.
Yeah.
And let me see here.
If it says mandatory, we have to go to the county court page and pull their mandatory form.
Yeah, it's not the county. Oh, the county may have it, but
the court.
It's entire for the entire California.
Right, yeah.
Let me
And you would just send these electronically to us and we'd be
it would come on an email.
Yeah, ready to go.
So I want to show you because all right, so this is an example of the spreadsheet. So there's one page that has a summary. Then there's another tab that shows cash, the inventory. Then we have a summary page and details for cash and equivalents and additional property received. So these are examples of the pages that we had created in that Excel. It's fairly rudimentary, but it does what it's supposed to.
Yeah, that's good.
And I want to show you this accounting because I look at this and I'm like saying, gee, wow, this is a work of art. And I'm not kidding you. It is a work of art. Okay, so we have the GC 400 sum. We know what that is. Now we're looking into spreadsheets, and this is in a little different format. We have property on hand in the beginning, banks, receivables, notes, stocks, all the other rules apply, and including the house. Now we go through what happened during the year. Remember, we started with income. So here is a list of all the income we got during the year in chronological format. Just like a check register. Gee, we got 1 cent of interest income. Whoopee-doo, it shows. And this is all chronological for the entire 2 years. Now, we get the court in a different format. This is receipts again. We're going back through the same data, but this time it shows interest income from Bank of America by category. Interest income. So the court can see what the B of A statements probably should look like. And so we get income chronological and then by category. So they can look at which way do you want, fish or fowl, different ways. And here's the gain schedule, gains on sales. Now we're going to go into disbursements and the same drill. We're listing every expense or disbursement chronological for the entire 2 years. Okay. Now, losses, okay, distributions to beneficiaries, and what is our property on hand at the end of the account period. It's like the ending inventory and appraisal. And if you recall on the government form, there was a column for market value. I would include that, you know, try to match it up to the government form. So this is a real work of art in terms of, you know, you turn in something like that and you're bound to get a gold star from the judge.
So this is another way of doing what we just went through.
Correct.
And you're saying this is a 5-star way of doing it.
If you can. It's you know, handout, I think number 3. Where am I? No. Handout number 2. So if you're able to do that, or you know, it's just another way to do it, and it is frequently done and it's acceptable. However, on that beginning, this you cannot turn it in with this on top. You have to use the real GC 400 sum approved by judicial counsel. You could have this underneath it. Another thing I want to point out, when you turn in your bank statement, you have to turn in original bank statements with your accounting to the court. You can redact a little bit on the account number, leaving the last 4 numbers or something, but they're not kidding. And when they set up this rule, everybody got their bank statements in the mail.
Rex,
Well, everybody and their brother trying to get electronic statements so they can save work and tell you it benefits you. I would ask the bank to give me paper statements. Now, what they've recently come up with is another system where you can go online, print the computer statements, but you have to include a verification under penalty of perjury that you have not modified the bank statements. That's exactly how they came off the internet.
Rex, when I talked with the courts just a few weeks back, one of the ladies who was helping me and told me about this class also, but she said they've recently changed the bank statements and that the only one we have to turn in now is for the last month, the last one we receive. So like for us, that would be in March. And that we don't need to turn in all the others anymore.
I have not heard that. What was that?
Contra Costa.
Okay, I have not heard that. Do you know what probate examiner said that? Was it Erica?
I would have to look, and I will look here and see if I have that name.
But what we're talking about is 11 pieces of paper, or maybe 22. So what's the downside? You just turn them all in if they didn't need them. So what?
Yeah. Yeah,
I'm not going to do that. I mean, unless I can go on the court's website, they have a section called Rules of Court, local rules. If the local rules say it, I'll do it.
okay.
The local rules do not, and it's not under the California statewide rules of court, and it's not in the probate code, I'm not doing it.
Okay.
And I don't mind running my printer for 11 more months. So what? We burn paper like it's going out of style.
Well, we have all of our statements, but they're we don't get them in the mail. We print them off of the computer.
Okay, that's what I was saying. You have to put a verification under penalty of perjury that these are unmodified directly as they came from the bank. And it has to be on top that you're verifying under penalty of perjury, it's just like it was. So, and that is a fairly new rule.
Okay, yeah, and I don't know who the probate officer was, but I did speak to her on August 22nd, and she said we only need the last bank statement.
Yeah, it was
And,
either Dana or Erica,
Yeah,
one of the two.
I think it was Erica.
Okay, she's been there the longest, and I
Yeah.
would not argue with her, but I tell you, I'm still doing it until I can see it in writing.
Okay, that's good advice. Thank you.
Yeah, I call it citation. I rely on the law, and somebody wants to pin me down, and I'll show them what I relied on. Now,
And so if we have online printed statements, where do we go to get it authorized or whatever you called it?
okay, so what I was referring to is a form. I don't know of any form that you can get online, but what we use in court petitions at the end is called a verification. And a verification is that you're telling the court, okay, I'm asking for this, that, and the other thing, give me the kitchen sink. And you get to the end and you say, everything I said earlier was true and correct under penalty of perjury. And sign it.
Oh, we just sign it then, okay.
Yeah. Okay, verification, completing. Okay, so if you want to look, Code of Civil Procedure, Section 446 and 2015.5. So those are two code sections that talk about it. But basically it's saying, you know, what are you doing? You're saying, Your Honor, I didn't think with these statements, I didn't change them, I didn't cut out anything. They're exactly the way that I got them from online, and I certify under penalty of perjury. They have not been changed or modified. Signed
Okay.
and done. And you head up the form on the top with the capital letters in the center called verification. And you identify the account number in the bank.
Hey,
Okay, if there's no other questions, I'm going to bring Tamara back and she will continue to illuminate this subject for you.
Rex,
Oh.
Rex, I have a random question.
Okay,
And I don't want to throw anybody under the bus, but my office in their inventories do not include personal property. And let's say you had some fancy car worth $100,000 or something, but she doesn't include jewelry, furniture, any of the sort. So I have to do what my attorney says, correct? And then say we sell something, you have to report the income in your Schedule A.
Okay,
So that sounds like a predicament for,
no, not really.
Okay.
What we do is, it's impossible to determine the contents of a house.
or the value of some
Exactly.
items.
So we
Mhm.
might just arbitrarily, it's called swag, some wild ass guess. And it's,
Stuff we all get.
and you say that we think the contents of the house is worth $6,000. It, so what? I mean, it's common. And if you sold a piece out of that 6,000, okay, we'll show it. But that's how I do them.
So you have that on your
Lump it all
INA?
together as one number, household items and personal effects.
Yeah, she
6,000.
doesn't do that. And then,
Fine.
and
If it
so
works,
just,
fine, but
okay,
it's not true,
correct, yeah.
because when we have decedents pass and they have all the stuff in their house, we might have an estate sale.
Mm-hmm,
We might have to pay $4,000 to get it removed. I mean,
right,
it might have some value, it might be antique, all kinds of things.
right.
And to ignore it, to me, I wouldn't ignore it. But
Okay. So
if
when I
the
come
court
work for
accepts
you,
it,
I'll put it in.
yeah, you blame me. Yeah, that's fine. You just throw a number in and say, hey, what's that? Well, I was told that's what I'm supposed to do. And
Yeah,
it's justifiable. Is there an asset there? Yes. Do we know really what it's worth? No. Is it worth going in and getting an appraisal? No. It's like, they call it de minimis. It's small, we're disclosing it, and it's not worth a hoot, and I told you about it.
okay. Thank you. This has been really good. I've learned a lot. I appreciate
Good,
it.
good. That's what we try to do. And I'll bring Tamara right back for you.
Thank you.
Everybody's real happy.
Hello, all.
Hello.
Are you ready for this to be over?
No,
Okay. So, as I explained earlier, it's funny when I come in, Rex uses the mouse on the left side. Even though he's right-handed, I use it on the right side. So I always have to change everything around for him. Okay. So I am moving on to, you have prepared your accounting. You have a headache, you have your glass of wine, and you're ready to quit because you're done with all of this. No, I'm kidding. And you have your accounting, and so what do you do with it, or how do you get it in the court, get it approved? You do all that. Sorry, I'm tying my shoe. So we're gonna work on next, or the training is next going to be the petition. And so it's going to be the petition to approve the accounting, or asking the court to validate all of your expenses, receipts, and things that you have done for the account period. So one of the things you'll need to do is search the internet for pleading paper. It's PLEADING. It's blank, it'll be blank, but it will have the numbers along the side. Now, I just said something really silly. It'll be blank, but it'll have numbers along the side. No, what I meant is none of the information on the right side of the ruler lines will be there.
And he also has it in that form thing, because I was able
That's-
to bring it up.
You're correct. He also has it there. So you would want to, anytime you're submitting documents to the court that are not on court forms, need to be on pleading paper.
Oh.
So you're gonna start off with your name here. And basically, this is just going through a copy of like remember the inventory and appraisal, we had the headings. You're just kind of doing the same thing. Name, address, phone number, if you have an email address, attorney for, you will list that. Come down a couple lines, and in this case, Superior Court of California, County of Orange.
Now,
I don't see anything on my screen. I just see a wood panel. Is that the same for everybody?
He has
Yeah.
moved it. I'm so sorry.
That's
Better?
okay. There we go. Thank you.
You're welcome. Sorry, here's the pleading paper. Again, this will be the same header as the inventory and appraisal. Superior Court, Orange County. Over here, we have conservatorship of the person and estate. It could state if you were only a conservatorship of the person, but think about if you're only conservator of the person, you wouldn't be doing an accounting. So that would not be the title on the document. It could be just the conservatorship of the estate, which means estate means money. The person as her name. Now it could be that she goes by a different name or a maiden name, or you would list all of them. You would put your case number up top. And in this case, it's our first account for the ladies that are on their fourth account. Yours would be fourth account current and report of the conservator and petition for its settlement. In our case, or only in our sample, we have a sale of a depreciating property. Do not copy this title if you didn't have that sale. You would leave that off. But this is also the only time you can ask for allowance of fees paid back to you for your duties. And it's the only place you can ask for attorney fees. Again, if you don't have and you're not asking for any of these, do not put it in the title. Yours might just say fourth account current report of conservator and petition for its settlement. And that's it, period. You may also include, you want allowance, that's up to you, etc. But only include what you're asking for. Hearing date and time, I always put the hearing date and time, even though you don't know the hearing date, it'll be blank, because when you submit it to the court for filing, they will write on here the hearing date. They will also give you the hearing time. So include the date of hearing, time, and department on this paper.
Okay.
But it'll be blank, because you don't know what that will be. I do not include judicial officer because they change. You may at time of filing, depends on if you're in Contra Costa, it's either Finstermacher or Judge George, but by the time your hearing date comes around, it might be a pro per or somebody else, pro temp, or somebody else filling in for the judge. A pro per will never be the judge on your case, I promise. Because that would just be you and me going in and sitting in for the judge, right? Okay, so then you'll start it off. Sometimes I'll say the name first, petitioner. I will put in parentheses. Don't use here and after. I actually, if I put quotes around conservator, that means from now on, I will only be referencing the conservator. I won't actually say the name of David. So as the conservator of the estate, which that's wrong, because if I follow this, it should have been conservator of the person and the estate, but I think the estate only turns in the accounting. So maybe that's not why it wasn't read, but the name of the person that's being conserved. And you're going to present for settlement and allowance your verified first account, second account, third account, fourth account, and report. So what is important? Let me remind you that every document you submit to the judge, to the court, must stand on its own. What does that mean? That means anybody should be able to pick up your document and know exactly what you're talking about and exactly what's gone on and what do you want me to do with it. Do not ever put something like, when you issued me the letters. No, put the date you were issued. Don't, the judge, they have a whole lot to do and they are extremely busy and they want to help everybody and they want to do things right, but they're not going to spend time going through the file and looking to see when you got letters or anything like that. You must put it in the papers here. So we started off with the appointment. So me, the petitioner, was appointed conservator of whom, when. And this will be the same thing you repeat on every single accounting. So if you've already had an accounting turn in, don't go through trying to figure it all out your own self. Copy what the other person did, because it's not going to change, right? Your appointment's going to stay the same. So just copy whatever they had, because it worked. So this person has been acting as the conservator. Our inventory and appraisal was filed on this date, showing a value of this, because then they're going to immediately look at your accounting and make sure your accounting is somewhat in this range. The period of the account, so whatever period your account covers. In this instance, it was March 8th. Remember, you're going to follow, for the ones that are doing the fourth one, you're going to follow and start your new time period. So that's a date you would include here. Charges and credits are from the GC 400 summary page. So you would just state this. Authorized investments. Always remember, as a conservator, you must keep the money in an interest-bearing account. That does not mean, or there is no excuse, well, the conservator herself just had it in a checking. Well, you now have put it in a new account and it must be in an interest-bearing account. Let me tell you a story long ago, and I haven't seen it recently, but we had a conservator that did not put money in an interest-bearing account, and they were just a friend. So years and years and years went by, and then the conservatee passed away, and her heirs actually sued the conservator for the interest they lost during the time that the conservator was managing the account. It was a few thousands of dollars. The court came back and the conservator, out of their own pocket, had to pay that beneficiary the interest they lost for not having the money in an interest-bearing account. So make sure the account, even if it may be a penny a month or sometimes 0, at least it's in an interest-bearing account. Okay, statement of liabilities. You would include it. No taxes are due. There's no outstanding judgments. Remember, in our case or in our sample, there was a sale of an automobile. So you're going to put in there, okay, I did sell the automobile because she can't drive. She cannot maintain a license. There's no reason to have this vehicle. It actually costs us more to keep it because we have to keep insurance on it and oil changes, even though it's not really moving, and just we know, so we don't need it. Now, I state on the inventory and appraisal, I had it on attachment 2. Why? Because it's a non-cash asset. Item number 7. And I had to sell it for a loss. There's nothing wrong with that, as long as it is really not as long as you sold it to a friend for a loss, because then they think, okay, what did you get from the, what, you know, you're actually benefiting from that. You can never do anything like that. Sale of furniture. You didn't need the furniture because now the beach home is sold. Now, sometimes, or most of the time, I don't even indicate it, but remember on when we were doing the inventory and appraisal, you put furniture and fixtures on the inventory and appraisal, and then you sold them. So you have to state that. Otherwise, I myself, just me doing them, would not have put the furniture and fixtures in. When the sale happened, I would have recorded sold furniture and fixtures. So on my receipts description, I'd have a description. But you may do that any way you wish. Then we had a sale of real property. Again, hun, realize my sample is to give you a variety. If you don't have these things happening during your account period, you may skip a few of them, and that would be starting only at 7. Do not. I've said this before. I accidentally said, okay, you just skip. You wouldn't include that in there. Then I got an accounting back from a court, and they had me review and correct it. And they're like, I don't understand. All this is missing. Well, the person who was completing the petition decided they only had 1 line item or 2. They put the account period and then their appointment. That's all they had. They said, oh, well, you said the rest of the stuff, if it wasn't necessary, don't put it on there. That's not what I meant. I only meant starting at set. You can, if you don't have number 7, if you don't have number 8, if you don't have number 9, do not include it. You could have something else in between there. Additional bond. Remember, I asked you the question. Sometimes if you know you don't have enough money to cover your bond, maybe you'll go ask your bond company to increase your bond. I tell people, don't do that. Wait for the court to tell you you have to increase it. But in the sample it gave you, they went and increased the bond because they sold the vacation home. So remember, their cash before was only like 50,000. You sell a home for $1 million now, and now you have $1,050,000. You need to make sure you cover the cash. But again, wait for the court. No affiliate relationship. This is really important for you to indicate this. Do not skip it. it says I have not hired a family agent or anybody of relationship to me. Now, I'm going to give you some other examples because hopefully it'll help you remember this. So say for instance, I have a conservatee that I'm taking care of, and that conservatee has a house, and the landscaper of that house came to me and said, hey, guess what? I'm taking a month off and I'm going to Brazil or Paris. It doesn't matter. Anyway, I'm taking off for a month and I can't mow the lawn. Well, I know the conservatee lives in a HOA, a homeowners association. So I go, oh goodness, I mow that lawn once a week, right? So I don't do it, I have them do it. So I go, oh my gosh, I'm gonna have to find somebody to mow the lawn. So I go off and I'm trying to figure out who's gonna mow the lawn. My son happens to walk in the door from college because he's on summer break. And I go, oh my gosh, I didn't even think about you're on summer break. So I need you to do me a favor for this next month. Once a week, for a very short time, I need you to go over and mow this person's lawn. And he says, okay. And I say, well, I usually pay the gardener, let's say $40 every time he comes to mow the lawn. But since you're in college, I know you need the money. So on and so forth. I'm going to pay you $60 every time you mow the lawn for the month, and then the gardener comes back, so you got to stop. He says okay, and he runs out to do it. He's happy as heck. There is a huge problem with that. Anybody want to even guess or come up with what you would, or if you see it a problem? Nobody wants to answer me. Okay.
Can you hear us?
Yes, I can hear you now.
We heard nepotism. We heard you increase paying someone out of someone else's money.
Correct.
I don't know.
I am allowing my son using somebody else's money to get more money than I would pay the regular landscaper. Now, I'm going to say the same scenario, and I'm going to go back and I'm going to say, I told my son, look, I pay the landscaper $40 every time he comes and mows the lawn. Do you want to do it for $40 every time? Do you see a problem with that?
Not as big a problem as before.
How,
I would think that you would, it would be okay, but you need to report it in your petition. Tell the court about an unusual item and explain.
Kind of yes and no. The only thing I would do is, because you already have landscaping in your accounting, right? Because the accounting's either a year or two, and the landscaper was only gone for a month, right? So still under property maintenance or whatever category you use, I would still list landscaping. And then for all other 11 months as they go on, because I go in chronological based on the date. So January, it would be, I don't know, Rex Crandell, February Rex, and I go through the month, and then all of a sudden I change it to Antonio. I would just put his name and the same amount of money, right? When I got back to this part, or the petition for the approval, that is when I would indicate, yes, my landscaper was gone for a month. I paid my landscaper $40 every time he came to mow the lawn. So when I hired my son, who was home from college, I also paid him $40 every time. As long as it's the same and you're not changing or giving more. If you give even less, okay, better. But does that mean they got less of a nicer landscape. You know, I don't think that really matters. So it's really important to indicate whether you've hired a family member and have paid that family member. Now, if you hire the family member and they do it for free, do you need to tell the court? No. But if you paid them money that out of conservative account and not your own account, then you must indicate you paid them.
Yeah, we have some that the caregivers are family members, and we ask the court to confirm and approve, and we request that and put in the petition and then in the prayer also, which I'm sure you're gonna get
Correct,
to.
which we're
Yeah.
gonna get to, yes.
Yeah.
So just remember, as long as you're being upfront about it, you're not trying to hide anything.
Right.
You're not trying to do anything illegal. You're not, like I said, your son is not getting advantaged more because it's not my money. So I don't care if I say, oh yeah, I'll give you $100 every time you come because it's not my money. I'm not spending it, right? Don't think that you have to keep the same attitude or the same mindset that it's your money. And or even like, say for instance, if it was my money, oh, I'd still pay him that. No, think about, be a little bit more mindful that it's not your money and the court is watching how it's spent, and so are family members. Okay, rolling down, compensation. You are allowed compensation. In fact, in Contra Costa, we have a local court rule that sets out, your compensation rate. I'm trying to find it right here in my quick papers. In Contra Costa, a non-professional fiduciary, which would be what you would be, as you don't have the credentials of a fiduciary, is $75 per hour for all of your work. Now, what does that mean? Does that mean the conservatee lives in your home, you take care of them 24 hours a day and you want to be paid 24 hours a day? No, that's not going to happen. It's more so like you leave in the house for doctor's appointments, you taking them out, maybe grocery shopping, maybe you take them out for haircuts, the dentist, maybe you take them out for a fun trip to the zoo, or I don't know, to visit family members or something like that. Yes, you can record your time. You would have to record your time, and you can ask to be compensated for those hours. Again, keep it reasonable. Understand that although you realize, especially I think it's Shirley who's doing it for a friend, it's a whole lot of work and you're tired and you're like, what in the world did I get myself into? But I think it's more the love for that friend and praying and hoping that the blessing you give to that friend will be returned to you when it's your time that you need somebody. And it's really just a very difficult, but you get joys in other ways for helping somebody who just can't. And just know your deed it might be unappreciated by others, maybe out in this world, but there are a whole lot of people, especially like me, who appreciate everything you're doing for them, because I just cannot imagine. I would just do anything and everything for them, and I can't imagine there are many out there that just have nowhere else to go and what to do. So just keep that in mind when you're asking for compensation, but you are entitled and you are allowed to ask for that compensation. again, this person says, okay, I spent 150 hours. This was my mother. I'd have a hard time charging my own mother, but I get it if I had a bunch of brothers and sisters and they're doing nothing and blah, blah, blah. Okay, I get a little bit of it. So what did I do is, so you would have to explain the things you did. For instance, they visited the care facility once a week. They made sure she was getting proper care. All her personal needs were met. They marshaled all the assets, paid all her bills, managed the estate, arranged the sale of the automobile, which she can no longer drive, listed the house, the vacation house. There's a whole lot of work that went into that so that they could raise money for the care. They rented out the regular home. So that means interview people, you know, go through all of the stuff that entails, and you've received no compensation. Let me make this a very important part. When you're doing a conservatorship, do not ever pay yourself, even reimburse yourself. Do not do it until you've received the court's permission and order. And where do you do that? Right here on this petition. What really is horrible sometimes is to think that you may front money for now and you won't get it back for 2 years because you're not doing another accounting for 2 years. There is such thing as, if you think there's going to be a regular amount of money, like say for instance, I was doing another conservatorship recently where the person lived in a beautiful care facility, right? And there was certain in the home or the center there was certain little things they could buy, like they had their regular maybe food menu, but maybe they could buy like an extra pot, or maybe it was a store that also had like and I don't want to say like razors, maybe lotions and soaps or things like that that the conservatee could buy. So what we did for that is we went in with the court and asked for a monthly allowance that was given to the conservatee, and it's pretty frugal. I'm talking, I think it was a monthly allowance of $80. So that we could use that $80 for really anything that she wanted, whether it was a haircut, her hair dyed, her nails. Now you can write a check for that regularly, right? That's not the problem. But let's say that I'm trying to use an example, like you go out all the time and, oh, here's another really important one. I'll zero back on that one, about the going out and eating. There just might be things that you pay for and you don't want to wait the 2 years to get reimbursed. You can ask for it in this petition if you know about it ahead of time. If you don't know about it ahead of time and you have to use your money for whatever reason, you cannot get reimbursed until you're asked. This is the only thing. Only thing you cannot reimburse is conservator reimbursed expenses or attorney fees. Anything else you can pay from the conservatee's account. Now I'm going to go back to the meals. Be very careful. In fact, I have 4 of them sitting on my desk right now, accountings that I'm working on for conservatorships. One of them, the gentleman is getting the conservatorship of the estate, not the person, of the estate taken away from him. I think it was pretty unfortunate, but I'm not going to talk bad about our courts and what they did and how it happened, blah, blah, blah. But I had in this case a gentleman who he takes care of his mother. His mother has uncontrollable bowel problems. let's just say, and has incontinence. So they go to quite a few places, not anymore because her health has declined, but used to go because mom used to love going gambling. So I think once every 2 months he took her to go gambling, and maybe Reno or places like that. And she had accidents in her clothing. He stated that, and reasonable to me, he stated they were staying in a hotel, you know, he wasn't going to ask to have those clothes washed, things of that nature. They ended up throwing it away. Now I'm talking maybe just like a regular jogging suit type, like sweats and a coat. He went out and bought a new one. Well, he went to a somewhat expensive store. The court actually charged him back for that purchase because they said that he did not really have the right or should not have went and bought more expensive jogging suit, or he should not have thrown away, which I still question, should not have thrown away the actual jogging suit and washed it. That's disgusting to me. But you know, there's so many other things I could point out. Just be careful and mindful. Oh, and then I guess he also bought her several pairs of Nike tennis shoes, and they said she wouldn't know the difference between Nike and an off-brand, so you really didn't have to spend the money on the Nike shoes. I feel if that's what she wore before she became ill, that's not a court's business to say she can't wear them still when, you know, she's older. That's wrong to me.
Yeah, she's allowed her dignity, I would think,
Yeah,
you know.
but the courts say, well, she wouldn't even know what her dignity is because she lost capacity. But
That's
still,
ridiculous.
you know, wrong. I don't agree with it. But again, I'm not saying anything about the courts. So another thing, different one I have where the conservator, his mom, and they go on an outing, like I think they went to like a zoo or a park, and then afterwards, and her grandkids were with her, and I think it was 6 of her grandkids. And so afterwards, so sad, but afterwards they all went to McDonald's. And the grandma at the time wanted to buy her grandkids a Happy Meal, and I really, honest to God, it was a Happy Meal. So grandma bought 6 Happy Meals for her grandkids and a little hamburger for her, and the conservator got charged back the hamburgers, all the Happy Meals that the conservator bought her grandkids, because they stated the conservator did not have capacity to understand that she was spending so much money on the Happy Meals for her grandkids. I disagree with that wholeheartedly. If she's always bought, you know, as a grandma, I'm one. Let me say, that's my pure joy to take, and I know it sounds silly, but to take my grandkids to McDonald's for a Happy Meal, you know, go play on the little things and blah, blah, blah. And nobody's damn stopping me. I don't care if it costs me $200. That's one, you know, outing that month that I'll have to make other arrangements to save on other things later. But my grandkids know, and they love McDonald's, right? I do think it's wrong. Remember, when you're using somebody else's money, you must be very, very, very frugal. One more instance, and I'll tell you, I have another one sitting on my desk that instead we have a conservatee who has I think cerebral palsy or one thing like that, so not mentally has lost capacity, but she's in a home, and and it's mom who's the conservator, and mom says every time she goes visit, and it's about once a week, she takes her her favorite Chinese food. So it's either the wonton soup one time, then it could be, I don't know, honey walnut prawns another time. And I don't have a problem. I didn't see a problem with that whatsoever. The problem I did have is she's trying to tell me she brought her daughter wonton soup, and I look at the price, and the price of the wonton soup was $79. And I looked at it and looked at it, and I go, I get Chinese food, every food is expensive nowadays, but $79 for a soup for the daughter. So I saw it quite often, and I said, something just doesn't seem right. So I contacted the conservator, and I asked, because I was doing this, I do most of my accountings are for law firms, so it's just not me taking it upon myself to change these. So I called the conservator, and I said, I just don't get this. Are you sure? It doesn't make sense. And then she proceeded to tell me, well, she also got herself food. And so she got her a dish and the daughter a dish, and had the daughter pay for the whole meal. And she thought it was okay because she was going to visit the daughter anyway. And I said, absolutely not okay. You can never spend money like that. You can only buy the conservator's meal. And then one more other one, which I thought very strange, is I had one that every month the conservator was withdrawing funds, and I went through and asked, well, I don't get why every month you're withdrawing funds, maybe 200 per month. And she says, well, I'm pulling it out and saving it for her funeral. I said, excuse me? She says, I'm pulling it out and saving it for the conservatee's funeral. I said, absolutely no, not, never, cannot do that. I don't care. Quite a few things go on there. Problem is, she's saving it in an account in her name. So really, if the conservator was to pass away before the conservatee, the conservator has a bunch of the conservatee's money, but who knows that? Nobody. Like, you cannot commingle funds. You can never do anything like that. When the court would never, never agree or okay you having a savings plan for funeral expenses on someone that's not your call, that's not your, I said, what? I wouldn't even know how to write in the petition to get that agreed upon. It's just the craziest thing I've ever seen. I myself, being the one, of course, I had a meeting with the attorney. The attorney went back to the conservator and said, oh no, absolutely not. You cannot do this. You need to refund. Then she wanted to refund the money so the court wouldn't see, now that I have brought this up, so the court wouldn't see what she did and possibly give her a talking to. And I had to explain to her, well, you realize the money comes out during one account period and now it's over. So you're going to put the money back in a different account period. Not only are you going to have the first one you've got to explain, but then you got to explain why the money comes back, because maybe you felt guilty, so you knew you were wrong, and it just makes it worse. But the only thing I said is you have to fess up. You have to, if you do something like that and it is truly, you had best intentions, somebody else tells you, no, that's wrong, that's weird, or, that's not proper. Just fess it up and say, I'm so sorry, I meant no harm by it. Here you go. But just realize it's somebody else's money, and please really just realize that. Okay, I know I'm over, so I'm sorry. I gave you a lot of extra little stuff. So I'm gonna go somewhat quickly, but not really. And those who have to leave because they already planned something, don't worry, you can always listen or take the class again. Okay, attorney compensation. An attorney cannot be paid any time prior to the court order. Even if they ask for it, you can kindly tell them this is a conservatorship and you realize you cannot take funds and I cannot pay you funds until the court orders it. So that's that. One of the very important things is to tell the court whether the conservatee is receiving veteran benefits or not. It's not either, it's not, if they are, then you have to state. If they're not, you don't have to state. You have to state either or. So keep that in there. Whether they are in a state hospital or ran by a state hospital, you must state that. Here, conservatee's address. I do not, again, this is public information, so I do not put that necessarily in here. I would state the conservatee is still living at her residence, or the conservatee is now in this care home. If it's a care home, I don't have as much problem giving the address, but if it's a personal home, I never give the address. The court knows where she's at. If I say she's still at home at her residence, they'll know where that is, what that means. Okay, statement of accounts. You're telling the court, I have not attached to the petition the bank statements, but I've delivered them to the court. There is a cover page inside all of this. In fact, I can switch to it real quickly. It looks like this, that it is the original bank statements. You would complete this and turn it in. I myself add a little bit more to this. On top, I would state confidential original bank statements, but the courts do know if you're turning in bank statements that they are confidential. What that means is on a search, you cannot search up these documents and pull them up if they are not listed confidential. Again, I could go to most any court, and in fact I do it, and if I'm looking for a case that I need information from, I can pay $1 a page and get a copy of this entire petition. And again, I'm using it for real purposes, but anybody else can also. So here is your cover page. I'm gonna go back. I think we were here. Yep. Again, you must submit originals. If you're using an online and you don't get original bank statements, you can go to the bank, ask them to print them, and then they have to certify them. And so what they do is they either put a stamp on the back front cover page, or they'll put their initials, or they'll do something to indicate it was printed and came from the bank, not you printing it off the internet and manipulating a PDF. Because I'll tell you, the way I work on PDFs, I can manipulate a whole lot of documents to read something different than they are. So the courts want to make sure you're not trying to do that. And so they make you submit originals. Capital changes, I've indicated here on the, this would be if there was any change in form. So I'm saying no change in form. Liabilities, this would be if in this case, my conservatee had a home loan. And so that home loan was with Downey Savings, and I'm still paying it. And what is the balance? What's the interest rate? I don't see those often. And in fact, I don't know that I've done one in the last few years that I've included this. Special notice is very important. I myself, and so can anybody else in this entire world, pay $40. Submit a request for special notice on your conservatorship. And that means once I file it, that every single time you have a court date or you submit any documents to the court about the case, you must send me a copy. Typically family members do this. I have quite a few, especially on probates where they take an inheritance advance. They do requests for special notices. So will franchise tax board if there's tax owed. So will a bunch of other people, like i.e. Say I have a conservatorship right now and they owned a parcel of land, and the person's brother, who is not part of their will, they're still alive, but not part of their will, is saying his sister actually gave him the parcel of land, so she doesn't own the parcel of land. And so now I filed a probate, and they've filed the attorney has filed a probate, and we're trying to get that through. But then this brother or it filed a request for special notice because he really wouldn't have received notice other ways. I mean, there's many different ways, reasons why people would request special notice. You should, as the conservator, always, you are the one to receive if somebody files that on the account, and you just need to make sure you notice them every single time you submit a document to a court. So now we're getting down to our prayer. So the very ending part. So in your prayer, what are you asking the court to do once you've said what this is? So it's, you want them to approve and settle the report. You want them to approve all of the acts and what I did in it. And that means in this case, you sold the vacation home, you sold the car, but separately, they've listed out here, prove that I sold the automobile, remember, for a loss. I sold the furniture and fixtures. Now, and this is the other part, you have to remember that upon settlement, I would like to pay myself $500 as compensation for the year. Remember, that's $500 for 150 hours of work. It's very low pay. Again, you're allowed up to $75 an hour. That upon this, and I'm sorry, I should have said that depends on your local court rule and what county you're in. I think it's pretty statewide, but always look it up first. Okay, upon settlement, I hired an attorney in this example, so he wants to be paid $3,500. And for an attorney to get paid anything, they have to fill out this very detailed invoice, and it has to say what they did, what the benefit to the conservatee was, how many hours, what their rate was, and they have to turn in a whole lot more than just asking for a fee. Then I tell the court, any other thing that you think is proper, you grant it. You're going to date it, you're going to sign it. Now, typically in this sample, I see it this way, but actually it's usually switched. So the attorney signs up here, the conservator only signs the verification, but you would leave this off if there's no attorney. And lastly, a verification. There has been so many times that I get people who are doing proper work that contact me and they're like, Tim, I don't understand. The examiner notes just keep saying I need a verified report, or verification was missing, or I don't get what they're talking about, what they need. Every time when you submit your document, you must have a verification. It is your under penalty of perjury. Even if you are the only one to sign this, you're like, well, I sign the document. Nope. You must also include this verification. You're stating you're the conservator. Here is my account and all my schedules. I know what's in this document. I know I have submitted it with all my true beliefs, blah, blah, blah. And again, the most important part is you declare under penalty of perjury that this is correct, and you will sign your name.
So I have a question, Tamara.
Yes, honey, go for it.
We talked earlier about if we're going to submit the online bank statements that we print out, that we need to do a perjury, whatever you just called it. Would it look like this, only it would be about the bank account, and then we'd just sign it under penalty of perjury statement?
You could, but I think that they're more looking for it to have been printed at the bank. But if you're going to do it, then yes, on your separate attachment, remember you have your cover page,
Right.
and behind that includes the bank statements. And then behind that is, no, actually behind the cover page, again, where it says confidential original bank statements, you would want your verification as the very next page. Don't put it as the last page, because then likely, like, an examiner could get it and look and go, oh, these are printed copies, I'm not accepting it, and put it down. And they haven't even got to your last page that said under penalty of perjury, right?
Okay.
So I would make it number 2, so it's the second thing they saw.
Okay.
Any other questions?
How much do you charge to do all this?
Mine typically, me myself, I do an hourly rate, and I only say that because sometimes there's complications and there's other things that I do them very often. So it's attorney. I don't take as long as you would take. In fact, much less time than you would take, because I have my steps, I have my procedure, I know where I'm going, I know what I'm doing, and I don't have a thinking process. The only time that that changes, and sometimes I get a little bit higher than other times, is when I have to think again, when I have to call the conservator and go, you know what, I'm having a problem with these meals. You're saying a bowl of soup is $70-some, and in my head, I just can't make that work, or other little things. And once I have to start getting into that and figuring out things, as opposed to just a smooth push through, then it could increase. Typically, depending upon like if I gave samples, and I'll be honest, some conservatorships are 500. I have some extremely complicated, intense conservatorships that go up to 10,000. It really is a huge, but when I say those with 10,000, I'm talking the conservator has 15 rental properties. And some of those rental properties are apartment complexes, and those apartment complexes have many apartments in them, and I've got rent coming in, and expenses going out, and and those accounting reports end up to be about 200 pages, and yeah, those are the kind that become difficult.
For just a basic does that
They're
also,
typically about 500.
does that also include this narrative part?
You mean the petition that for the approval?
The petition and the standard account forms?
Yeah, if it's asked for.
Yeah.
The thing is for any LDA, and if you can find any LDA that does the accounting, as long as you ask them and say, I need an accounting and I need the petition that goes for it afterwards, then those can be prepared. But if it's not you asking for that to be done, depending on who the person is that you've asked to help you prepare this, they may or may not, because really we can only do documents at your request.
Yes, okay, thank you.
You're welcome. Any other questions? Anything you may have a query on, you're not sure about, you're scared about?
If we, because the sisters are gonna do this, for the other sister and my brother-in-law, who's a big part of this. So if we're moving along and we're doing this and we have a question that really came from this workshop today, can we shoot you an email?
Of course.
Or-
So you can shoot either Rex or myself an email. We work together, but then we also work independently. I mostly work independently from
Okay.
him. He is an attorney. I am not. I'm an LDA. And so, but I work for several different attorneys. So you can either, and I'm pretty sure in all of his, he blasts, I likely hasn't gave any of my contact information, but I'm trying to see if I can find it here in his thumbnails.
Your information is, oh, no, it isn't. I thought it was on this form. The
Oh
French.
yeah, no, so he only has his, so mine, if you wish to write down, my email is, it's CA and then the word legal, LEGAL, and then DOCS, so docs,
Mm-hmm.
the number 2 at gmail.com. And I am Tamara.
Okay.
And also like, so if you got to a point that you said, hey, can you take a few minutes and just glance and maybe see if it's right? I will do that for you without a charge whatsoever. If it's something that I cannot figure out why I can't balance, or I'm not balancing, or things like that, that will take much more than 15, 20 minutes, 30 minutes of my time, then I would have to bill for that time. So you can use your judgment if you wish to do that. If not, just proceed with submitting it to the court. Because, and remember, you're going to get examiner notes, which means about 2 weeks before your hearing date. Well, let me say, Contra Costa is really good. Alameda is very good also. About 2 weeks prior to your hearing date, there are called examiner notes where you log into your case and the examiner has gone through and said, hey, you're missing this, or your page 5 is wrong, or you need to explain why you bought tennis shoes and separately bought black laces, or whatever they have as questions. Then you have only till your hearing date to record or answer in a declaration those examiner notes. Likely, if you don't answer and you just let them go, the court will continue your hearing and put it off and ask you to get those notes and figure out what's wrong and answer the questions. So it's always best to glance, make sure you look. A few other counties, and I'm talking some, not Solano, Santa Rosa, Sonoma. I couldn't think of the county, Sonoma County, and a few other counties. You get the notes the day before, after 4 p.m. and how do you possibly correct anything before the hearing? You know, it's impossible. So other courts are much more kindlier. And probably, and I forget, Lisa, how often down south do you guys typically get examiner notes?
We get notes for Orange County about 5 days before, sometimes it's 30. But we check notes on all of our cases every Thursday. And
Right.
I'm the court desk. I'm the person who has to respond to all the notes.
Yep.
So I get a stack, go through them, did that. There's a lot of swearing that goes on from my end. I try to keep it quiet, like, I did that. You know, they don't always go back and look, but I wanted to make a comment. And then, okay, LA County is 3 days, and they actually post them on the tab reads probate notes in the probate site on the courts. Riverside's a little different, where you have to look at the tentative rulings and scroll and find your case. But I wanted to comment on, at least we do mostly LA and Orange County, that we have to give notice of those hearings to everybody in a conservatorship, all relatives, from if there were grandparents, parents to grandchildren.
Correct.
So,
anybody on the case that requires notice must be given a separate document, which is the notice of hearing.
Yeah, and that's where they're really, really particular. You need to verify that you sent notice to this person. We can't verify their address, but the notice list has the address. And I say, my notice on this date, they live there. So there's a lot of, I shouldn't say time wasted. I know the examiners have their duties and jobs to do, but
we have to love them. I know that it's frustrating as heck. I can't imagine. I'm not in their shoes. I'm not in their place. I know they've got a lot going on, but then again, I know, to me, they don't work as hard as us on the outside. I'll tell you.
I have a comment.
Yes, hon.
I'm very familiar with that. The thing that we have to send out to our siblings and whomever. But what I have not been able to find is like the page, the standard form that I found online through Contra Costa. There was only room for like 4 names. Well, there's 7 of us.
So what we do is I mark.
Wait a minute.
So I'm sorry.
I couldn't find the second page anywhere.
What you can do is there's an attachment called, it's a miscellaneous form. You can just type it on a blank piece of paper and I just call it notice list and list the names and address. And you can put their capacity, like adult sister, you don't really have to, but you can just say, so on the bottom of your notice of hearing on the proof of service page, on the bottom, there's a box, and you'll say attachment, and it says you may use form number.
Okay, so it's optional.
So it's not shall, it's may.
Okay, thank you.
You're welcome.
I'm glad you brought that up. That was driving me nuts.
You can use a blank piece of paper, and let me see. I think it's the DE 120, which is the notice of hearing. I'm gonna bring it up real quick over here. So this is the notice of hearing that you're talking about, right? And this only gives 5 pages. You will see that down here, there's a box and there's another one. And this is just the DE 120.
Yeah, I have that Okay,
So if you also search the DE 120 in parentheses MA, which I will show you, a
what's MA stand for?
DE 120, I can't tell you what it stands for, hon. Not that
Miscellaneous
I just
attachment.
don't know. Attachment, yeah.
Yeah,
So the DE 120 MA, no, I don't want it from there. Use a reputable site too. Don't
Yeah.
use
I find it's easier for us just to attach the notice list separately.
There it
Then you
is.
don't have to go from box to box and all of that. And then you'll use the next, in 2 years, you'll use the same list. If there's a
Yes.
change of address, you can just change it in your computer.
Oh, because it's optional to
It's
use that
optional.
form.
I
That-
never, and I tell anybody that comes in new, don't use that. Just always just use our notice list unless you forgot to send notice to the public defender. Okay, so then I'll send a separate notice and type that in because
Yeah,
where I work, the courts are hardcore about notice. I don't know about your county.
Yeah, they're not so horrible up here, but the one I do see that gets forgotten quite a bit is especially conservatorships, every conservator has a court appointed attorney.
Right.
And they're not part of who you think. So when you filed the conservatorship, you listed all brothers, all sisters, all aunts and uncles, all whatever who were living. And so you seem to reuse that service list, and you forget that there's now been a court investigator who is now become appointed. You forget the conservative has an attorney. You forget to notice them. So I see those two forgotten quite often to remember. So just be careful about that. But hun, there is another sheet, and this is which would look like it, and it's just a whole sheet full that you
Yeah. Okay,
and then you can do several of these. And so
Yeah.
it would be page 1 of 2 or 2 of 2 or 1 of 3 or whatever.
so just use a blank sheet and,
I use a Word document
Yeah.
and create my own service list.
yeah, okay. Thank you.
Any other questions?
This has been really, really helpful today.
Aw, thank you. Now
Even the-
again, remember, you can we give the class about every 2 to 3 months. I don't think we have
Right.
one anymore this year,
No,
but you're
every 8
you're able to take the classes as much as you want. Again, we repeat my samples or my examples tend to be a tiny bit different based on who's in the class. But they're the content is pretty much the same. So you can come on, take it again, take it every time we have it, or not ever take it again. That's totally up to you.
Well, we appreciate it. That it seems like a simple thing, but it was so important was, does the form say mandatory or does the form say optional?
Yep.
I know, right?
Big
Yeah.
words.
Big words, big words. Okay, thank you all. And
Thank you.
I appreciate everything. I'm gonna call Rex in for one more second so he could say goodbye. And let me know if you have any questions, and good luck to you all.
Thank you.
And have a great day. Let him say
And we may be in touch.
thank you.
Thank you, Tamara.
Rex.
Good luck,
Can you hear me?
everybody. It's hard
Yeah,
stuff.
he's not here, so I'm gonna end it. I'm sorry, y'all. I will have a great day, and just let us know if you have any questions.
Thank you so much.
Thank you, hon. All right, bye.
Bye, everybody.
Leave meeting.
Yeah, me too. I'm gonna see how I can do this.